the consent of the other side, I beg to mention item number 3, my lord. In this matter, I've misplaced the brief, my lord. Can it be taken up on Monday next, my lord? So that I can reconstruct a brief.
Other side, you have informed.
Yes.
Ms. Bhattacharya. Bhattacharya. Heard no, as prayed for by Mr. B. Sharma, Learned Standing Counsel, NF Railway, with consent from MSP Bhattacharya, Learned Counsel appearing for the petitioner. Relist on
Monday, man.
when is it?
9th. Much.
May it, Your Honor. It will concern back to mention item 43 and 44, Your Honor.
43
and 44. In item number 44, as per the last order, you have required to file the dusty affidavit, Your Honor. So it takes some time to file the affidavit.
and 44.
Yes, Your Honor. Let it be after the vacation, Your Honor. Summer vacation.
As prayed for by Mr. Edar, Learned Counsel, appearing for the petitioner, relist after 3 weeks on a date to be fixed by the registry to enable the petitioner file the affidavit of service
Yes, Your Honor.
as required
Much obliged, Your Honor.
on a date to be fixed by the registry.
Wait, please, Your Lordship. With apology, my lord. Item number 59.
59.
Okay, that's a hearing matter. Can it be tomorrow or Thursday? It's a joint prayer. Tomorrow or Thursday? Non-motion reading.
1 second, Mr. Bonnie.
My lordship.
59. Other side is there.
Yes, I've had a word, my lord.
You are for the respondent.
Petition.
Petitioner.
I'm not the petitioner.
You're not there in APDCL.
I am.
But
It's a
you're
motion by the
referring
APDCL.
against the APDCL.
The APDCL is filing it.
Oh, achha, sorry. As prayed for by Mr. S. Banik, Learned Counsel, appearing for the petitioner with the consent from
SP Roy.
the other side, relist on such and such date. When do you want?
Any Tuesday, Thursday, any Tuesday, Thursday. Fifth. The interim to continue.
Interim, if any, shall continue till the next date of listing.
My lord, with the consent of petitioner advocate, I beg to mention item number 14.
Item number
14.
14.
Yes, my lord.
Additional affidavit was supposed to be filed here.
My lord, for that 2 weeks time required, my lord.
You are for the,
BTC
Huh?
on behalf of SR Rabha.
you are for BTC.
Yes, my lord.
It is an eviction notice. Have you taken consent from the other side?
Yes, my lord.
When do you want it?
2 weeks, my lord. 2 weeks required, my lord.
Not 2 weeks. Is there a stay there?
Yes, my lord.
Any stay in the matter?
Stay is there. Stay is there. Interim order is there.
As prayed for by Mr.
P. Hazarika on behalf of SR Rabha.
T.
P.
Hajorika, Learned Counsel, appearing on behalf of Learned Standing Counsel, BTC, relist after 1 week on a date to be fixed by the registry to enable the respondent file the additional affidavit as required in the matter.
Obliged, my lord.
May I please, Your Lordship? Lordship, item number 41, my senior is out of station. They say I am seeking adjournment for the them.
41 is the order matter.
Yes, my lord.
You find out why it is come for order. We will see when the matter reach. Next.
May I please, Your Lordship? Your Lordship, with due consent of the other side, I beg to mention item number 42 of the daily list, Your Lordship.
42 again is an
42.
order matter.
Your
Let us-
Lordship, we need
Don't
1 week
make
time
any
for.
mention for order matters. Let us see why the matters are on board.
Lordship,
pass
we need 1
appropriate
week time
orders.
for filing the amended petition, Your Lordship.
Amended writ petition.
Amended writ
I
petition.
for respond number 7, my lord.
You want to file amended with
Yes, Your Lordship.
40?
42.
42, my lord.
In 42, MS?
N. Mohanta.
MS?
N. Mohanta.
N. Mohantal, Learned Counsel, appearing for the petitioner, seeks 2 weeks' time to file the amended writ petition. Prayer is not opposed. Relist after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
Deeply obliged.
May it be please, Your Lordship. Lordship, I beg to mention item number 12, Lordship. Matter may be adjourned for the day only, Lordship.
Well,
12, Lordship.
you are for,
I'm the petitioner, Lordship.
but I think revenue was supposed to file an affidavit.
Yes, Lordship. I'm saying on behalf of MS Sheikh, and MS Sheikh is out of station.
That's all right, but what about the affidavit in opposition? Let us see when the matter reach.
Yes, sir.
This court will accommodate you.
Yes.
Yes.
May I please, Your Lordship? I beg to mention item number 11. Kindly adjourn the matter for the day, Lordship.
The service is completed. You are for the petitioner,
Yes, Lordship.
as prayed for by MS.
As spoken.
S. Fukan, Learned Counsel for the
After 2
petitioner.
weeks.
List after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
May I please your lordship, item number 45 of today's list has become infectious, so the matter may be closed.
Huh?
Item number 45
Huh?
for today's list has become infectious, so the matter-
Infraction.
Yes.
BTC or cooperative, anyone there?
On behalf of Corporation Department.
Your name?
Mr. R. Islam,
Islam is not here.
appearing on behalf of R. Islam.
No, you are submitting, it has become infractions. Where is he?
She is out of station,
Huh?
out of station.
Your name?
My name is T. Talukdar.
MST Talukdar on behalf of Mr. R. Islam.
Yes.
Learned Counsel for the petitioner submits that the matter in the meantime, the writ petition in the meantime has become infractious.
K.S. Sodial on behalf of
So and so, Learned Counsel on behalf of
S.K. Talukdar,
SK Talukdar, Learned Standing Counsel.
Standing Council,
Revenue.
Corporation Department.
Huh? Corporation Department is present. In view of the aforesaid endorsement made by the Learned Counsel for the so and so, the matter stands dismissed on being infractious. Yes.
Motion PA item number 1.
Yes, Mr. Singh?
May please your lordship, my lord,
That
the
means-
learned counsel from Manipur, your lordship, could not join the VC because of the,
But this has
Oh.
come the first time after.
yes,
the
it has
earlier
come for the
effective-
first time.
Oh, I think you will need to,
Need to file the written objections.
how much time?
As per he was asking for sixth of this month.
It's up
Friday.
to you, you'll be, is it enough?
Any-
for you?
But no, it will take time because
Next
you
week.
has to come 2
Next
weeks.
week,
2 weeks,
next week,
any
next
date after 2
next
weeks, your lordship.
after 2 weeks.
Any date, your lordship.
Issue notice, MS, only one respondent, na?
One.
MS, M Kumar, right?
M. Kumari.
M Kumari,
Yes.
learned retainer, sorry, your designation was retainer?
Is retainer counsel of the CBI.
Retainer counsel CBI, 6 accepts notice on behalf of the
19,
respondent
okay.
and seeks 2 weeks time
Video
to file
make a
objection.
Right.
Prayer is granted,
20.
relist on such and such
Okay.
date. Yes, when do you want?
28 June, your
Yes.
lordship, 20, to oblige.
Much up.
May it please your lordship. Lordship, the matter pertains to tax remission scheme, lordship, of 2008. Lordship, the affidavit, they have filed an affidavit in 2019, lordship. Lordship, the pleadings are complete. If it's fixed on a hearing date, particular date, then the matter can be disposed of, lordship. Small matter. It's pending for so long.
What is the issue?
Issue is
Okay.
relating to tax remission, lordship. 99% tax will be refunded back to us.
Tax remission.
Tax remission, lordship.
How much is to be remanded?
6 lakhs only, very small.
No, 99% you said.
99%.
Why is this not done?
Lordship, because Lordship may kindly come to the revisional order that is at page 119, Lordship.
You are challenging the revisional order here.
The assessment as well as the revisional order, Lordship. Both we are challenging, Lordship. Lordship, in the revisional order, in
One
page,
second.
yes.
Assessment is 2013.
It is pertaining to assessment year 10-11, Lordship,
Okay.
and it has been done in
And this assessment is done under which provision
section 36, Lordship,
of the
of the Assam VAT Act.
VAT Act?
Actually, these involves CST transactions, interstate transactions. The department wants to say that when it is an interstate transaction, you have to provide the C forms also, then you will get the tax remission. But in the scheme, there is nothing like that, that you have to fulfill the obligation. When I am already under
Failing it.
already in exemption, then even if in some C forms,
But
there is some
authorities, I think, is there on this point.
lordship, it is there, but right now I don't have that.
But there are some authorities.
Yes, yes.
No, but the matter is listed. You should have come. The matter is for admission.
Yes,
You yourself say it's a short point. I was
Yes.
trying to see if it can be disposed of.
Lordship, otherwise also Lordship.
You are enjoying an interim.
No, lordship, no. interest.
Then it is your interest to
Yes,
have
yes.
the matter disposed of.
Lordship, without that authority also, lordship may kindly, I can take your lordship to the provisions that will show that page, kindly lordship may see page
So
one.
your entire issue is on non-submission of the C form.
I
That
have
is-
submitted
that-
C form.
Huh? You
I
have
have-
submitted.
I have submitted C forms, but they found some defects in my C forms.
Gotcha.
So the correction time was not given to me. And the C forms was not given back to me also for corrections because I cannot produce a second leaflet of the C forms. They have to give me back the C form, then only I can make a corrections, or they have to provide me with
What
some
was the
time.
defect in the C form?
That also they have not said. Lordship may kindly see the assessment order. It's very short, 2 pages.
Yes, let's
assessment
see.
order. 111 lordship page.
Page 111. Yes.
Shri so and so of the business and authorized representative of the dealer appeared and produced books of accounts relating to interstate sales during the period. The dealer is a manufacturer of plastic caps. The dealer furnished monthly returns for the period. Sridas has appeared and produced books of accounts verified. The following sales were made. Sales to registered dealer at concessional rate of tax, so and so. Sales to others, export to other countries. Books of accounts tally with the furnished returns furnished against the claim of sales to registered dealer. The dealer is required to furnish C forms of so and so gross value. Against this,
Against this means against the claims of sales to registered dealer.
yes, lordship. If I give C forms, then it will be 2%. Otherwise, it is 5% tax, lordship. Against this, the dealer furnished 165 leaves of original C forms, an amount of so and so. Furnished C forms verified, and on verification, 15 numbers of C forms C forms for rupees so and so found defective. For 46 lakhs, that 5 crore amount I had submitted, from that 46 lakhs was defective and as such rejected. Rest amount of value C forms for rupees so and so found in order and as such accepted, and concessional rate of tax allowed. Accepted C forms filed in record. There is also short receipt of C forms for so and so and rejected C form for form sale of so and so taken as sales to others and assessed to tax at 5%. So there will be two values, my lord. One is 4661 and the other value is 9789,027.
Yes.
These two will be charged at 5%. Then sales are recorded in the books of
So there
accounts.
were some short receipt of C forms.
Some short receipt and some
rejected.
some are
Two issues,
rejected.
right?
Two issues. And another issue will come, lordship. The
One
export
second,
also.
One second, Ms. Pope. Yes.
There is an export. Sales are recorded in the books of accounts of the dealer and made with proper invoices. So my returns, my invoices, my sales, those are recorded. I am not evading tax or anything. There is an export of so and so during the period. The dealer in support of claim of export furnished 6 numbers of exemption certificate of Royal Bhutan for so and so and 1 export document certificate for so and so, which are verified, are accepted, are filed for record. Short receipt of export documents for so and so taken as sales to others and assessed to tax at 5%.
What does this mean?
Lordship, so 30 lakhs was the amount which was the export. From that, some amount of certificates, 6 certificates I gave. 1 certificate they did not find it proper. Value of that certificate was, lordship, 6,237, lordship. So that again they will charge to 5%, lordship. Anything for which I am not able to give a certificate, they will charge it as a local tax. That is Assam VAT.
Okay.
On the basis of above observation, sales are determined as below. Lordship, this is the rough calculation. Lordship, next page, lordship will find the calculation is there. No other irregularities detected till completion of verification. As such, accepted books of accounts and assessments for the period completed as below.
So 2 irregularities.
Yes.
Short receipts and rejection.
Yes. One is rejection. One is C forms I have submitted less, and one is 1 export document also was defective.
1 export document? Short receipt of export document.
Yes, short receipt of,
So basically short receipt only.
yes.
So yes. Now, what is your submissions on all this?
Lordship, now my thing is that since the amount of exemption, they calculate an exemption limit actually in the terms of money, Lordship. That amount is 5 crore something, Lordship, in my case. From the assessment year 2009 to 2016. For 6-7 years, I get that exemption. So now this is for 10-11. In 9-10, I have used only 10 lakhs from that money. So there is lot of money in my account. So from my exemption limit. So in my thing was that even if the C form or this has been rejected, this exemption for so much
Now
technical.
against this, you have a appeal or
I
revision?
want to revision.
Revision. Appeal is
is-
not there.
Appeal is also there, Lordship, but I went to the revisional authority. I can go for a revision also. Revisional
Now,
authority.
where is the revisional authority's order?
Order is at page. It starts from 115, Lordship.
But generally, appeal, if appeal is not there, then revision.
Yes,
Generally,
Your Lordship.
here-
But we can directly approach the revisional authority also, Lordship. Question of.
Yes.
May I read this order, Lordship?
Yes, page,
Page 115 it begins, Lordship.
yes.
Heard the parties and perused the records. On a threadbare appraisal of the factual metrics of the case, the crux of the emanating issues requiring decision is whether exemption or remission granted by issuance of notification purportedly under Section 8(5) of the Central Sales Tax Act 1956 by the state government to eligible industrial units under purview of the Assam Industries Tax Exemption Scheme 2009 shall be available even without fulfillment of the conditions prescribed under Section 8(4) of the same Act. For sake of clarity in understanding, the following relevant provisions of the extracts thereof under the Central Sales Tax Act 1956 are reproduced below. Section 9(1) of the Central Sales Tax Act provides the tax payable by any dealer under this Act on sales of goods effected by him in course of interstate trade or commerce, whether such sale fall within Clause A or Clause B of Section 3 shall be levied by the Government of India, and the tax so levied shall be collected by that government in accordance with the provisions of subsection 2 in the state from which the movement of goods commenced. Section 8(1) of the same Act lays down every dealer who in the course of interstate trade or commerce sells to a registered dealer goods of the description referred to in subsection 3 shall be liable to pay tax under this Act, which shall be 2% of his turnover or at a rate applicable to the sale or purchase of such goods inside the appropriate state under the sales tax law of the state, whichever is lower. Provided that the central government may by notification in the official gazette reduce the rate of tax under this subsection. Section 8(2) of the same Act lays down the tax payable by any dealer on his turnover, insofar as the turnover or any part thereof relates to the sale of goods in the course of interstate trade or commerce, not falling within subsection 1, shall be at the rate applicable to the sale or purchase of goods inside the appropriate state under the sales tax law of that state. Explanation: for the purpose of this subsection, a dealer shall be deemed to be a dealer liable to pay tax under the sales tax law of the appropriate state, notwithstanding that he in fact may not be liable under that law. Now comes the
1 second.
yes.
Now, C forms are only in case of exemption, right?
My lord?
C forms are in case of exemptions, isn't it?
No, no, my lord. C forms are whenever I make a sale to the registered dealer.
Then it has to be
Ah,
submitted.
Interstate sales,
There
they
it
will
is.
give a C form, that dealer will give me a C form. And if I give to my state authorities, because the tax calculation assessment will be done by my state authorities. So my state authorities will charge me lesser. in
Because you have
2%.
already paid.
Because I have already paid and the CST certificate I have to produce, so they will charge me 2% instead of the
Correct. As per this section.
as per this section. So I have to give the C forms.
So
Then
now
only
if
I will
you
get.
don't give the C forms, if there is a short, then they will
They will charge me.
charge you more.
They will charge me more,
Charge you.
5%.
This is exactly what has happened.
Yes,
Because there were few of the C forms which they have rejected.
yes,
That means they have said that in respect of those items,
yes,
you have not paid.
yes.
That is why they said now you pay.
Now we. pay.
Correct.
Yes,
Isn't it?
yes,
And the other short receipt, because there were short receipts, so against that they have assessed you.
yes, yes.
And also that short receipt of exempted exported good.
Yes, absolutely correct, my lord.
Okay.
But
Yes.
only difference
Yes,
is
let's
after this
proceed.
will come, lordship. This is the section actually 8.4 which they are bringing in, according to which they say, may I read that, lordship? The provisions of subsection 1 shall not apply to any sale in the course of interstate trade or commerce unless the dealer selling the goods furnishes to the prescribed authority in the prescribed manner a declaration duly filled and signed by the registered dealer to whom the goods are sold containing the prescribed particulars in a prescribed form obtained from the prescribed authority, provided that the declaration is furnished with the prescribed time or within such further time as the authority may for sufficient cause permit. So there was this option also that they could have given me some more time to, because it is interstate sales. So some more time to furnish the documents, but I have to submit the document according to them. But in this case, my
1 second. So this document you had given within the prescribed time, correct?
yes
Only thing that document has been rejected.
had been rejected
Now,
because
is
there
there
were
any provision which says that if in case of a rejection or in case that within the prescribed time, if notwithstanding that you have given the documents, but some short receipts are there, some defects have been occurred, in that eventuality, a further opportunity for you to be provided, is that there in
that is what under section 8.4, lordship, the last line which I read, provided
provided that the declaration is furnished within the prescribed time
or within
or
further such
within such
as
further
the
time
authority
as
may.
that the authority may
So
for sufficient.
that
cause
further
permit.
time was not given to me.
So you mean to say that there is a power with the authority to give you further time?
Further time. And my lord, this case actually is also not about reasonable this opportunity. If opportunity was given, well and good, I would have submitted the corrected C form. My main thing is that lordship will come next section, which
Yes,
is there,
yes.
section 8.5, further lays down, notwithstanding anything contained in this section, the state government may, on the fulfillment of the requirements laid down in subsection 4 by the dealer, if it is satisfied that it is necessary to do so in the public interest, by notification in the official gazette and subject to such conditions as may be specified therein, direct that no tax under this act shall be payable by any dealer having his place of business in the state in respect of the sales by him in course of interstate trade or commerce to a registered dealer from any place, such place of business or any such goods or classes of goods as may be specified in the notification, or that the tax on such sales may be calculated at such lower rates than those specified in subsection 1 as may be mentioned in the notification. That in respect of all such sales or sale of goods or sales of classes of goods as may be specified in the notification, which are made in course of interstate trade or commerce to a registered dealer by any dealer having his place of business in the state or by any class of such dealer as may be specified in the notification to any person or to such class of persons as may be specified in the notification, no tax under this act shall be payable or the tax on such shall be calculated at such lower rates than those specified in subsection 1 as may be mentioned in the notification. Now, this exemption tax remission scheme that was taken up, this is under this section. That is a different thing, Lordship. This is the normal course of action that happens. But under section 8.5, when there is an exemption already given to me,
Yes.
when there is an exemption already given to me, so my question is that whether CFORMS has some little 1 or 2 small defects, that will not stop them from exempting me from the tax. Because the exemption notification is there in my favor, the exemption limit is there in my favor. Now, why that exemption was not given, Lordship, that I may take your Lordship.
1 second, 1 second. And now, where is the exemption notification that
Yes,
that is applicable in your case?
yes, ma'am. Because
As per
that is, because that is applicable because, Lordship, the exemption notification doesn't suffice. After that, I have to approach the department. After my commercial production starts, I have to approach the department. Department will give an eligibility certificate to me. That is
No, what is the exemption notification? What is the effect otherwise?
99% tax remission.
99% tax
Yes,
remission.
you don't have to pay 99%. Only
And there is a procedure and mechanism for
yes, yes,
apply.
ma'am. And that procedure and mechanism, I have fulfilled that, Lordship. My eligibility certificate is at page 107, Lordship, may kindly see.
No, before I go to that, so
Yeah.
under that you have to first apply.
Yes.
Then they give you an eligibility certificate.
And that also doesn't suffice. After that, I have to get an authorization certificate from the tax department because eligibility certificate is given by together with.
Now
the
here
department.
99% you are already tax free.
Yes. So why are they levying the tax on me?
Why is it done, Mr. Chakraborty? Yes.
No, they have the reason in the order, Lordship, in the revisional order.
Where? Let's see.
May I continue reading, Lordship,
Yes,
from
please.
118,
Yes,
Lordship?
please.
Perusal of the above quoted provisions clearly establishes that in order to claim exemption or partial exemption from payment of sales tax due, whether under Section 8.1 or under Section 8.2 of the Central Sales Tax Act 1956, by virtue of any notification issued under Section 8.5, because exemption notification is under Section 8.5 of the same act by the government, the interstate sales must be once conforming to provisions of Section 8.4 of the said act. The conditions will apply whether any notification issued on or after 13/5/2002 under purported exercise of power conferred by Section 8.5 expressly contains those or not. So Section 8.5 doesn't say about these conditions. So they have made it up themselves, Lordship. In the present case, the petitioner appears to have claimed following interstate sales: sales to claimed registered dealers, so and so, sales to unregistered dealers. However, he could file CFORMS before the assessing officer, total price, sales price rupees 4,36,000 so and so, only against the required coverage of so and so. Out of the filed CFORMS, 15 numbers of CFORMS covering sales of so and so were found materially defective by the assessing officer. The assessing officer determined sales purported by valid CFORMS at so and so, including 2% tax element only. The dealer also made export sales at so and so, but he could file the required document for availing exemption on this count at so and so. The assessing officer computed tax on central sales tax at rupees so and further tax of so and so on the unsubstantiated claimed export sales of so and so. Out of the total tax liability determined, the assessing officer transferred liability of so and so to VAT account for the purpose of allowing 99% exemption thereon, since the petitioner was holder of entitlement certificate under the Assam Industries Tax Exemption Schemes 2009 and had transferred only the same amount in his annual VAT return in form Annexure 9 of the 2009 scheme. Now, the main contention raised in the present revision petition is that the assessing officer ought to have granted 99% remission of the payable tax amount eventually determined by him under the central sales tax assessment by transferring the same to VAT account, since it being an eligible unit under 2009 scheme, was entitled for remission of 99% payable tax both under VAT and CST. The available monetary ceiling of exemption for the year 2010-11 was rupees so and so, which was sufficient to cover the 99% liability under VAT and central sales tax for the same year. So they accept that I have the amount which could cover the amount. The petitioner although makes an averment that he was neither given further time for furnishing the balance C forms, nor was provided with an opportunity to remove the defects in the 15 numbers of C forms covering sales price of so and so perceived by the assessing officer, he has neither produced the balance C forms during his revisional proceedings, nor has pressed the matter of removal of defects in the aforesaid 15 numbers of C forms. This is not correct, Lordship. Why will we not ask for the correction, Lordship? We will always ask for the correction, Lordship. Then why he did not, the next 3 lines, he says why he has not given the availability, Lordship. The superintendent of taxes, so and so, on the other hand, had defended the assessment on the ground that since central sales tax liability of so and so was transferred to VAT remission account by the dealer, the annual
Okay,
tax.
one second, Ms. Gope. Mr. Chakrabarti? Sorry, Chaudhary. See, it appears that exemption, and that's 99% tax remission. Now, one thing is admitted that they are eligible because you have issued the eligibility certificate, correct? For claiming the 99% remission. So that they are entitled to get that, isn't it? Now here you are, the assessing authority, instead of giving exemption to the full payment tax that they have paid, that they have done only to a particular portion of the tax paid, isn't it? That is the, have I understood the facts
Yes,
correctly
yes,
or not?
absolutely, Lordship.
Now, how can that be done?
Lordship,
Because apparently they are eligible, that you have issued the certificate.
Lordship, they are eligible
Hmm?
they are eligible for under the entitlement certificate for a particular period, or an amount is fixed according to their investment. Lordship, here, Lordship, they have done transaction, and whether that transaction has been done to claim that benefit under the interest rate, they have to produce the document which is in the form of C form.
Suppose they had failed to give the entire document.
Then, Lordship, as
that-
per the act, it has to be treated as
No, but
interest sale.
why you have not given them an opportunity then? Under that proviso, you could have given them a further time because
Lordship, that time period was given or not, neither we have stated in the
Correct,
affidavit.
correct.
That will be apparent from the assessment proceeding
But
record.
is that not necessary? Because under the provision, you could have asked, because here is a question where there have been short receipts and defected C forms.
Lordship, whether that opportunity was there.
Because that clause says, isn't it? This clause which Ms. Gope has taken us through, the provided that the declaration is furnished within the prescribed time or within such further time as that authority may for sufficient cause permit. So a power is there. Now suppose when you are doing it, you found some defects in some of the C forms. Then you found that some of the C forms have not been given.
Yes.
You could have asked whether
Whether-
that was asked.
That Lordship assessment proceeding record will reveal that I
Don't have it.
I do not have it.
All right, then I'm fixing it. I'm admitting it and posting it for hearing. In the meantime, you have it.
Yes,
For the hearing date, you have all the records.
yes.
Okay. Third, MS Gopil,
My lord, they may also take instructions on the next paragraph that I was reading.
one second, you let me know when I am just giving. Heard MS ML Gopil, learned counsel appearing for the petitioner. Stop. Also heard Mr. B. Chaudhary,
Yes.
learned standing counsel,
Finance and
finance and taxation. Stop. This you say this writ petition requires a full-fledged hearing. Admit no formal notice as parties are represented by their respective councils. Post for hearing when?
And
Lordship,
last week of June, next 2 weeks I'm traveling.
Last week of June, not July. In the month of July, on a date to be fixed by the registry. Mr. So-and-so, learns the, Mrs. So-and-so, Chaudhary, learns standing council so-and-so, shall have the records of the
assessment proceeding.
assessment proceedings as well as
Revision proceeding also.
revisional
revisional
proceeding.
proceedings
Yes.
available with him for the perusal of the court if necessary.
Alright.
Much obliged.
Yes, boundary wall has been
Demolished.
demolished. Why
Patna-
demolished?
My Pataland for construction of some drain, Lordship.
PWD.
Yes,
Where is
there.
PW? Mr. Chaudhary, you are only there.
Yes, madam.
10 days time to complete your instructions was given. Do you have your instructions?
Yes, my lord.
What is your instructions?
Lordship, with regard to that three lessors, it is not clear from the instruction, Lordship.
So then further instruction is required.
Yes, Lordship.
Lordship, it is clear, I have the Jamabandi, where it is, my land is shown as 4 kata 18 lessons. After they demolished my wall, now they have taken up a joint measurement. That is in page number 24, Lordship.
You have not filed an affidavit here.
They filed an
No.
affidavit.
Lordship, PWD,
We have filed.
What
Government
is
has.
your stand, Mr. Goswami?
3 lessons land is short. And then they have to take decision lodge on that lodge.
What, sorry, what was your stand?
There is 3 lessons land is taken by the lodge.
3 lessors land has been taken.
Lodge, yes.
Out of?
Total lordship.
No, here he is already having his land.
4 kata 15 lessons. 4 kata 18 lessons was my land.
Oh,
After they broke my boundary wall and joint measurement was carried out, then they found the land to be 4 kata 15 lessons.
Now this demolition has been done by them, PWD.
Yes.
So PWD's affidavit perhaps is
Yes,
required to
sir.
clarify.
but Lordship, on the joint verification also, it was found 415, but as per the land record, it is 4 katas 18 lesser. That 3 lesser, Lordship, that is not clear from the record.
So-
From the instruction, Lordship.
What do you want to do?
Lordship, short time period, Lordship. I
All right.
get it.
Heard Mr. Heard
Gogoi.
Mr. So-and-so, Learned Counsel for the petitioner, your name?
M. Gogula.
M. Gogoi. Also heard Mr. B. Chaudhary, Learned Standing Counsel, PWD, and Mr. N. Goswami, Learned Government Counsel for the state respondent. Mr. B. Chaudhary, Learned Counsel, Learned Standing Counsel submits that pursuant to the earlier orders passed by this court, he has received instructions. However, the same is not clear as whether as required in respect of the area of the land. And accordingly seeks a short time for having the for placing the complete instruction. The prayer is not opposed. Relist on, yes, next week.
Lordship, let it come after 2 weeks, Lordship.
Why 2 weeks? You just have to get this clarification.
Lordship, it has to come from Dibrugarh, Lordship.
2 weeks is a date with you on such and such dates.
Let me fix a date.
My lord, one submission. Lordship has already heard the matter, so if it could be, my learned friend is also there, if it could be kept part, heard me.
No, no. It's an admission matter. Yes, insurance amount not paid.
Not said.
Why?
I have filed my affidavit for respondent number 2 and 3. Yes,
2 and 3.
2 and 3.
I think it was. Yes, you want to file anything? Affidavits have been filed, I think, by all respondents. 2, 3, 4, and 5.
4 and 5 together.
Yes.
Lordship, yeah, you have to furnish the service copy of the affidavit
Huh?
by the respondent 4 and 5.
4 and 5, you have not given.
Not,
When will be furnished?
Huh?
not furnished yet.
So yes, my lord, because otherwise it will not come on record. I will give a copy. I'll give
Give
a
him
copy.
a
Yes,
copy.
copy is not given to me.
And you want to file reply or not?
No, after receiving the copy from this respondent 4 and 5, I want to file the.
So I will say that.
Yes.
Complete your rejoinders, because otherwise this matter, it is in your interest to have the matter disposed of early.
Yes.
So, all right, you take it like this. Heard, Mr.
P. Kalita.
A.
P. Kalita.
P. P. Kalita, learned counsel for the petitioner. Stop. Also heard, Mr.
Pesnak,
Esnat, learned counsel appearing for
2 and 3.
2 and 3, and Mr. M. Barua.
Yes.
Learned counsel appearing for respondent number 4 and 5. And Mr. N. Goswami, learned counsel, learned government counsel appearing for
Ombudsman. Ombudsman, insurance ombudsman.
respondent number one. You are there? Ms. Gordler, are you there? Mr. Barwa, so and so submits that an affidavit has been filed on behalf of the, sorry. It appears that the respondents have already filed their affidavit in opposition. Mr. So and so, learned counsel for the petitioner, submits that however, the affidavit in opposition on behalf of the respondent number 4 and 5 has not been served upon him. Let Mr. Barwa furnish a copy of the aforesaid affidavit in opposition to the learned counsel appearing for the petitioner within the course of the day. Mr. So and so, learned counsel for the petitioner, further seeks 2 weeks' time to file rejoinder against the affidavit in oppositions filed by all the respondents. Relist after 3 weeks on a date to be fixed by the registry.
That's it. Have a like.
Contractual bill.
This has become infractuous actually.
Infractuous.
Yes. Payment will be should apnar leka hoga. Final bill file sir. Everything. Like. The prayer in the writ petition is with regard to non-payment of the running bill.
You have a look. You have a look. I'll take it up after 1 or 2
We have not
matters.
only paid the running bills, the final bill has been paid.
All right, let him have a look. Mr. Counsel, you have a look.
Look.
I'll take it up after 2 matters.
Lots,
Just have a look. If needed, you call your client.
lots.
You both come and inform my court master, but together.
Yes, yes.
Don't, one of you don't come and inform him.
Sure.
Ex gratia.
Yes, your lordship.
Yeah.
Lordship, I want to withdraw this petition.
Withdraw.
Yes, Lordship.
Sure, because your lordship, similar writ petition by the honorable coordinate bench is dismissed, your lordship, for
Dismissed.
granting, yes, for granting ex gratia amount. That is WPC 27.
You have an order.
Yes.
I have emailed your lordship,
क्या बोलवा दी सर
email course.
क्या print उलवाना है You want to withdraw
Yes, Lordship.
item number
7.
7, your lordship.
heard Mr. M. Saikya.
On behalf of M. Saikya.
What is this on behalf when withdrawal matters? If you want to withdraw, the counsel should be present in court. Heard Mr. Your name
J. Firdaus.
J.
Firdaus.
F.I.
RDOUS.
J. Firdaus, learned counsel appearing on behalf of Mr. M. Saikya, learned counsel for the petitioner. Also heard M.S.
And
N. Borderloy, learned standing counsel, revenue, and Mr. N. Goswami, learned government counsel for the state respondent. Mr. Sorry,
J. Firdaus.
Firdaus, learned counsel for the petitioner, submits that Mr. Saikya has received instructions not to from the petitioner not to press the instant writ petition and accordingly seeks withdrawal of the same. In view of the aforesaid endorsement, the writ petition stands dismissed on being withdrawn.
Yes, your lordship.
অলপ পিছত মাতি দিয়ক।
May I please, your lordship?
Yes,
Lordship, the matter has become infructuous.
infractions.
Yes, lordship.
MS
You
Nanda.
Nanda.
Huh?
You Nanda. on
You
behalf-
na? Heard MS U Nanda, learned counsel appearing on behalf of,
J Laskar.
huh?
J Laskar.
On behalf of J. Laskar, learned counsel appearing for the petitioner. Also heard Mr. N. Goswami, learned government counsel for the state. MS Nanda submits that the petitioner submits that they have received instruction from the petitioner not to press the instant writ petition and accordingly seeks withdrawal of the same. In view of the aforesaid endorsement, the writ petition stands dismissed on being withdrawn.
Obliged.
Ex gratia.
Kindly time being, Lordship.
Huh?
Kindly time being.
Sorry?
Kindly time being, Lordship.
Time?
Time being.
Time being?
Yes, Lordship.
Why?
My learned counsel is on court number 20, Lordship.
This is also ex gratia.
Yes, Your Lordship. Same, Your Lordship.
Lordship, it's a different matter, Lordship. Although it's a ex gratia, but it's different, Lordship.
All right, you want
Kindly
Mr.
time,
Sakya to be
please.
here?
Yes, Lordship.
Let's see. It judgment to liya niki. Miss Bodole je disla. Just print the opportunity. If I took for you.
Yes, Lordship.
It's fine.
But in this case, I need some time, Lord.
You need time.
Yes, sir.
In item 12,
12, Lord.
heard Mr.
S.A. Wasi.
Sorry,
S.A. Wasi on behalf of Mr.
F.A. Vasili, learned counsel for the petitioner. Also heard Mr. N. Goswami, learned government counsel for the state respondent, and MS Bhattacharya,
Yes.
learned standing counsel, revenue. Mr. Goswami, learned counsel, seeks 2 weeks' time
Lord.
for completing his instruction and in order to file the return. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry.
Much less.
You were supposed to file a rejoinder, Mr. Majumdar.
Lordship, I filed an application for impleting the Union of India, Lordship, as an IA. I feel, Lordship, yes,
One
listed.
57.
Lordship.
Sorry, I one दिया कागज. You want to impede Union of India?
Lordship, Union of India represented by this Secretary to the Government of India, Ministry of Rural Development Department, Lordship. By virtue of the Honorable Court of the Lordship 21, 2025.
Which order?
Lordship 21, 2025, Lordship, in the main read petition, Lordship.
Order to some. That was your submission. The court didn't say
Lordship, no.
direct you. So
Actually-
why you refer to these orders as if there is there is a direction from the court?
Lordship,
Yes, why is the government of India necessary in this case to be implemented?
My lord, these schemes are central government scheme, my lord. That is why
So you are having no objection?
no objection, my lord.
Heard Mr. K. A. Majumdar, right? A.
Lordship,
K. A. Majumdar, learned counsel for the applicant. Stop. Also heard Mr. S. Datta,
My lord.
learned
Standing Council, PNRD Department.
standing counsel, PNRD. Anybody else? No.
I am for
My colleague is appearing for the
District Commissioner.
And
District
Mr.
Commissioner.
A. Bhattacharya.
S. Barwa.
Sorry,
Barwa.
Mr. S. Barwa, learned
Government Advocate.
learned government advocate for the state respondent. Stop. This application has been filed for impleading the Union of India, represented by the Secretary to the Government of India, Ministry of Rural Development, Department of Rural Development, Mahatma Gandhi NREGA division as respondent number 7 in WPC number 3470 of 2022. The brief facts of the case is that
The paragraph 2, Lordship, I have stated.
the Joint Commissioner DORD Assam filed an affidavit in opposition stating, within quotes, you get it here, huh? A to 8, para 2, page 4. In view of the aforesaid averments made in the affidavit in opposition, it is essential and imperative to have the presence of the Union of India in the accompanying writ petition for effective adjudication of the writ petition. That being so, the impleadment application is allowed. Accordingly, it is provided that the Union of India, represented by the Secretary to the Government of India, Ministry of Rural Development, Department of Rural Development, Mahatma Gandhi, NREGA Division, Krishi Bhavan, New Delhi, 01, be impleaded as party respondent number 7 in WPC so and so. Application stands disposed of. Let an amended cost title be submitted before the registry for doing the needful in the writ petitioner, in the writ petition for doing the needful. In the
Lordship, I may be allowed to take steps to.
in the writ petition, you say that upon submission of the amended cost title in terms of order dated, give today's date, in terms of so and so in IAC 1457 of 2025, issue notice in respect of the newly impleaded respondent number 7. Anyone accepting for 7? Huh? Mr. Sharma, you want to then you say steps by registered post AD within 3 days from today and list after 3 weeks.
Lordship, may I serve the copy to the central CGSC, Lordship? So it.
But why you didn't tell some?
Lordship, I'll serve the copy to the CGSC, Lordship.
I could have said it. Anyway, then you just delete that and you simply say upon submission of the amended cost title date in terms of so and so order dated in so and so I, comma, list this matter before the bench. You let it come and then and once you file the amended cost title, you serve a copy.
Lordship.
And then notice will be issued. They'll accept.
Hello, please.
The payments have been received.
I will received instruct from that he has received the payment, but he has not paid, received the interest here. He has not received the interest because they have.
He has not what?
Received the interest of the payment. Because
he has received the interest.
Not here, he has not received the interest, but only main payment, bill payment. Is
What interest is the contractual matter?
After 4 years they have.
No. Immediately on completion of the work.
The bill amount is 2878.
No, there are 3 amounts, my lord.
No, in the prior portion, the amount is shown as 2878.
That was the running bill. We have paid 3 bills, my lord. The final bill was for an amount of 23,39,302. Prior to that, 2 other bills were also.
So you have paid including this.
This is the final bill and the PG money, SD and EMD is also released, my lord.
Nothing survived.
Nothing survived.
Right. Heard, Mr.
Yes, Islam.
S. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned standing counsel.
NF Railway.
NF Railway. This is item 6, huh? This writ petition has been filed seeking direction for releasing the bill amount of the contractual bill amount of the petitioner. Stop. The brief facts of the case is that the petitioner is an empaneled contractor of NF Railway. In the year 2018, the railway authorities issued NIT for the work SNT in connection with extension of ballast siding
Yes.
at Namrup railway station, wherein the petitioner participated in the tender process and upon being selected, he entered into an agreement with the respondent number 3 for the said work. Thereafter, the petitioner supplied the materials and completed the work as enumerated in serial number 62 and 63 of the agreement dated 16/8/2018. Thereafter, the petitioner submitted the bills before the respondent authorities amounting to rupees 28,78,728. However, the same was not released, for which the present writ petition has been filed. Today, when the matter has been called, Mr. B. Sharma, the standing counsel, so and so, places the instruction dated 2/6/2025 received from the office of the NF Railway Tinsukia
Tinsukia.
to the effect that there is no any liabilities pending with railways against the petitioner contractor. Stop. A copy of the aforesaid instruction placed by so-and-so is kept on record and marked as X. A perusal of the aforesaid instruction further indicates that the details of payment made to the petitioner are as under A to A. You will find it here, huh? In this instruction. In view of the aforesaid payments having been made to the petitioner, nothing survives for adjudication in the present writ petition. Accordingly, the writ petition stands dismissed on being infractious.
God bless you.
Non-payment of contractual liabilities.
Yes, Mr. Khatuniar.
Non-payment of contractual liabilities, my lord. They have filed their affidavit and admitted the amount, my lord.
And this has been pending since when?
Sorry, my lord.
Pending since when? Your bills have not been paid since when?
I have completed the work 2018, my lord.
Submitted bills 2018.
18, my lord. Yes, my lord.
So since 18, they have not paid.
Yes, my lord.
Despite admitted.
Yes, my lord.
Who is appearing?
Mr. S. Neogi, is the standing counsel for the Tiwa Autonomous.
Tiwa.
Tiwa Autonomous Council. My lord.
Yes, where is he?
My lord.
Get hold of him.
Yes, my lord.
Get hold of him. If it is admitted, this court will dispose it.
Yes, my lord.
Please, Your Honor. The pleadings are completed, man.
Pleadings are complete. This is allotment of RCC shed.
Yes,
The
ma'am.
market complex.
Yes.
Yes, Mr. Datta.
My lord,
Why are you not allotting?
My lord, on joint prayer, my lord. Lordship may fix the matter on a hearing date, my lord.
All right.
Admission hearing.
If
It
possible, then
appears,
17/6, my lord.
The learned counsels appearing for the parties jointly request of having this matter heard for final disposal on any admission date, at the admission stage. Relist on such and such date. When?
17/6.
On such and such date.
All right.
High level.
Cancellation of FP as license. Affidavits filed, Mr. Nayak?
Yes, Lord. We also file our rejoinder.
Yes, Mr. Ghosh.
Yes. My lord, here my lord, two read petitions are there, lordship. One.
The first, you are seeking an quashing of the inquiry proceeding.
Yes, my lord. In 319 of 2024, my lord. Subsequent to my lord, the suspension of my license, lordship.
Suspension.
Yes, suspension of my license. And my lord,
First
another,
one is inquiry and second one is suspension.
my lord, first one is my lord 6053 of 2023, my lord. That part, there, my lord, challenge the property of the search and seizure, my lord. Because in our humble submission, my lord, that was not in accordance to law, what it should have been, my lord. And after the search and seizure, then, my lord, our license was put under suspension. Followed the suspension, my lord, inquiry proceeding was initiated, my lord.
The inquiry, the search was, first of all, was it on the basis of some complaint?
On the basis of the complaint, some person made a complaint, my lord, on the basis of
So
that.
your whole challenge is that the search is illegal.
Yes, my lord.
Procedural
Yeah,
violation.
by procedural
What
violation.
is the procedure violated?
Procedural violation is this, my lord, as per, my lord, the Essential Commodities Act and my FPDA order
EC Act
1982.
Khandya? Essential Commodities Act.
FPDA order.
Can we attempt to take it up for finally discussion?
So far as second case is concerned, one inquiry is going on. And
Acha.
what is the status of that inquiry? That instruction, I think I have to obtain, lordship.
Do you have it by next week then?
Lordship, lordship.
Because I don't think much time will be required in this case
No,
because
no.
if this court is satisfied that there has been procedural violation, of course, one perception can be taken. If this court is of the view
Yes,
that
yes, yes.
nothing,
Lordship.
then another perception. I think that is the only argument for the first case.
Yes, 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 yes.
And whatever happens, suppose in the first case we find that search is illegal, then the second
Then the
case
second one is
automatically,
yes, yes, my lord.
isn't it?
And if only, my lord, in first case, if a lordship find it, yes, proceed, they have done according to the, then
Then
only second.
Then of course on merit.
Second, my lord.
Then-
Whether the violation of principle and natural
Why don't
justice.
we have it
before.
next week in the meantime, Mr.
I'll
Naik,
take
try
that,
to
sir.
see if you can have the instruction. Yes, heard Mr. Ghosh, BJ Ghosh, learned counsel for the petitioner. Also heard Mr. P. Nayak, learned addition, you are appearing as an additional
Yes,
advocate
yes,
general?
yes.
Additional advocate general for the state and anybody else?
No, my lord, only government.
Hmm?
Only state government.
All right. Mr. Nayak, learned additional AG, seeks a short accommodation to have the up-to-date status as regards the inquiry which is going on in respect of WPC 319 of 2024. Correct?
Okay.
Stop. Relist when? Next week?
On next week, the lordship continues, my lord, I know lordship's con. On 17, lord.
Huh?
17.
17?
Yes, lord.
No, not 17. 17, 18, Tuesday.
Oh, 10.
10th.
10th. Lord, oblige. Thank you.
Contractual bill.
Affidavit was directed to file, my lord. I need some time, my lord. I'm preparing the affidavit, my lord.
What is so special that is coming up in your affidavit, Mr. Datta?
My lord, actually what happened, my lord, these are election bills and our department's role are very limited, my lord, because
What? Department role?
role, yes, my lord, are very limited. That the NITs were issued by the Deputy Commissioner, my lord, and elections were held by the State Election Commission. They have forwarded the bills, my lord. We have forwarded to the Finance Department for additional budget, my lord.
So it is an admitted bill?
They can say, my lord, Deputy Commissioner can say.
My lord,
And for that, may I submit, my lord? For that, my lord, once the bills were submitted, but authentication bill was required, my lord. The finance department, my lord, queried that the bills have to submit along with the authentication certificate. Now, my lord, at this stage, we have issued,
Internal formality.
yes, my. This are going on,
Concerned with your internal formalities.
my lord.
This court is concerned whether the bill is admitted, not admitted. If the bill is admitted, it cannot be kept
My-
pending.
How much?
He has done his work.
My lord.
If his work is not disputed, there is no question of keeping the bills pending. Article 21 comes in.
Yes, my.
Bills are admitted, lordship, part payments were also made.
Yes.
So
Yes,
balance
what is
pending
that?
since 2019.
How much time? to finish?
Actually, these are my lord additional budget, my lord.
Right? This court is not concerned about all that. These are your requirements.
My lord.
You are in welfare state.
My lord, lordship may fix the matter immediately after vacation. We will try our best, my lord. In the meantime,
Yes, Ms. Das?
My lord, as per our instruction, my lord, that already sent to the
Corona instruction.
bills have been sent to the, my lord, PNRD department, my lord, and
Bill
again, my
sent to PNRD.
PNRD department.
My lord.
When did you send?
Corona
It
instruction.
is, yes, my lord, it's last year, my lord, 20.
Last year?
My lord.
28,
One
20.
sec,
Yes,
Mr.
yes, yes.
Doctor.
Yes, my lord. Sorry, my lord.
Yes,
Letter is of, my lord, 28/8/24.
2/8.
28/8 August 24.
Can I have a look at the letter?
Lordship, lord.
Now?
DC কি এখন আপোনাক দিছো যে মই এখন আপোনাক হোৱাটছএপত দিছো মই আপোনালোকৰ ফাইল মই কি ক'ম bachelor of Engineering.
What is this?
My lord, I have submitted this, my lord. This is the present status, my lord. For authentication of the bills, my lord, we have written this letter, my lord,
To whom?
to the State Election Commission and the Deputy Commissioners.
The
Next
deputy
page, the petitioners, my lord.
Given you.
No, my lord. Initially, that was given,
You see,
but
Mr. Latta, I'm making myself very clear.
yes, my lord.
This court is really not interested in your internal mechanism.
My lord, I can understand that, my lord. I understand that,
If a contractor has done his job
my lord,
to your full satisfaction,
my lord.
there is no reason why you should keep it pending for want of additional fund. That cannot be a ground. This is a welfare state. I'm making myself very, very clear. It's a
Well-
welfare state.
My lord.
And as it appears way back in September 2022, the additional district commissioner has sent the proposal for reimbursement of pending liabilities. And it was followed by, again, in the year 2024.
My lord,
And their stand is once the fund is received, pending liabilities will be dispersed accordingly.
my lord, I already said, my lord, our role is very limited.
Your limited role, I'm not interested. At the end of the day, who has to make the payments? Who has to have the funds?
Finance
available?
department has to release the fund, my lord.
Who is finance here?
Finance department, RTS.
We have completed them, lordship. No?
No, I can.
As a party.
Finance,
So, sorry, sir.
Initially, finance was not party, but now I don't
they've
know.
been
my lord.
included.
Completed, lordship.
Included? নাম দেখাইছে না এটা কিছু সব My lord, names are not showing in the cause list, that is why maybe.
When did you include them?
Lordship,
Order dated 11/12/24.
The order is all right, but in the writ petition, I don't find any amended cost title.
We have submitted, lordship, amended cost title.
Huh?
We have already submitted amended cost title, lordship.
নাই দেখা চোখ আছে নেকি চোখ When was your bill submitted?
Lordship, 2017 and 2018, Annexure 2 series.
Oh, number 6. All right, get hold of Mr. P. Nayak. Please ask him to be here. 2000?
17 and 2018, Annexure 2 series of the writ petition.
2017 and 18. Please ask him to be here.
Hello.
Mr. Counsel,
Yes.
get hold of Mr. P. Nayak or anyone from finance.
I'm informing also.
Mr. Datta, don't leave.
Yes, yes, I'll be there. My lord.
Call again.
My lord, in this matter, my lord, in the last occasion, we have great time to file affidavit in reply. You know, 2 affidavits have been filed, one by the deputy commissioner and other by the private respondent. But I pray for a week's time, my lord, then
You want to file your rejoinder?
rejoin them, my lord.
As prayed for by Mr. H. Gupta, Learned Counsel for the petitioner, relist after 3 weeks or 2 weeks?
2 weeks, my lord.
2 weeks to enable the petitioner file rejoinder against the
Against the affidavit filed by
against the evidence opposition file on behalf of respondent number 3 and 7 respectively.
my lord.
Only the prayer is that Lordship, the date may be fixed, Lordship.
Yes, yes.
Lordship.
Give a date after 3 weeks.
Lord, oblige.
This is the first time when the respondent are eager to have a date where you have to make a payment.
I think item number 21 starts.
My lord,
Yes.
Mr. S. Nyogi,
Huh?
Mr. S. Nyogi, my lord, for the Tiva council, my lord, he has some difficulty today, my lord. If I may pray for a date, subject to your lordship's convenience and subject to my.
These are contractual bill matters.
Absolutely, my lord, absolutely, my lord. He just intimated me as some
And
person.
admitted bills.
Yes, my lord. My lord, I fix it on Wednesday, my lord, because they have submitted, filed the affidavit also.
Heard Mr. N.J. Khatoniar, Learned Counsel appearing for the petitioner, Mr.
M. Sharma.
M.
M. Sharma on
M.
behalf of.
Sharma but are you there?
No, no, my lord.
Submits on instruction that Mr. S. Nyogi, Learned Standing Counsel, Tiwa Autonomous Council, has due to some personal difficulty is not available in court today, and accordingly on his behalf seeks posting of the matter on any other date. Prayer is not opposed, relist on
Wednesday, my lord.
Wednesday date to read on such and such day.
I'm grateful, my lord.
Oblige, lord.
This is from item 15 to 20.
One more item, my lord. One more item.
15 to 21.
21. My lord.
21 and my lord, 29 also, my lord.
And 29.
29 also.
29 to Yalagat.
Oblige, lord.
Illegal encroachment. Yes. Counter affidavits, not there.
We have the instruction, but railway is also required, lord.
Huh?
27.
What is your instruction, Mr. Goswami?
Yes, lord. Some land has been taken by the railway. Lord.
Some land taken by railway. Now, where is railway? Mr. Sharma, where is he gone?
Seven.
Railway is a party or not here?
Yes, party. Railway is party.
Name shown. And ask someone to inform Mr. Sharma or central government, whoever is appearing. Yes, you inform the central government, we'll take it in their presence.
I have the instruction, we'll file a.
But what are they going to do? Let us have them, because if they want to file something, let them file. I don't like posting matters in a piecemeal fashion, where today one respondent will take time, on the next day the other respondent will take time. If they want to file something, they should file, because I don't find any affidavits here.
We file them.
So get hold of someone from the railway.
Yeah,
Contractual bill.
Yes, Lord, that to file affidavit, Lord.
Who is going to file?
Lordship kindly,
B. Gogoi.
yes.
B. Gogoi. Mr. Goswami.
Lordship.
Mr. B. Gogoi was supposed to file an affidavit. Where is he? PWD. Anyone from PWD is here?
820.
Inform Koridok PWD. After some time, you inform someone from PWD. Land acquisition compensations.
Lordship,
My lord.
service completed, Lordship. Service completed.
Mr. Chaudhary, you are appearing for 5 to 12.
Respondent number
Private
5 to 12, my
respondents.
lord.
Private respondents.
Private respondents there. They have been served notices only on May, early month, on May.
On
And they are
16.
scattered all around Assam, presently
You
cut
want
off.
some time
We want some.
to file affidavit.
Yes, my lord.
All right.
We have filed.
You have filed. Heard Mr.
M. Dutta, my lord.
M. Datta, Learned Counsel for the petitioner. Also heard Mr. J.C. Chaudhary, Learned Counsel, appearing on behalf of respondent numbers 5 to 12. Mr. N. Goswami,
I'm for 2, 3 and 4.
Learned Government Counsel for the state respondent numbers 2, 3, and 4. Disaster Management, MSN Bordeloy, Learned Standing Counsel, Revenue and Disaster Management Department. Mr. J.C. Chaudhary, Learned Counsel on behalf of the private respondent, seeks 2 weeks time to file return in the matter. Prayer is allowed, relist after 2 weeks on a date to be fixed by the
My lord may fix a date, my lord, and there is an interim order that may.
interim, if any, shall continue till the next date of listing.
My lord may fix a date, my lord.
All right.
Obliged.
It is 30 is still,
In this case, I need some time, Lordship.
huh?
In this case, I need some time, Lordship.
Issuance of NOC. NOC for what?
NOC for sale permission. Yes.
Why are you not allowing him to sell his land?
Everything I have annexed here, Lordship. PTA already development.
Huh?
Only problem is there, Lordship. Only name is the problem.
Name.
Name of the purchaser also. It belongs to that.
After 10 days, Lordship.
Heard
Last
Mr.
couple
S.
sentences.
Islam, Learned Counsel for the petitioner. Also heard Mr. N. Goswami, Learned State Counsel. Mr. Goswami seeks a short accommodation to come to file return in the matter. No, this is a 25 matter.
Yes, Lordship.
Seeks 2 weeks time to file return in the matter. Prayer is allowed. Relist after 2 weeks on a date to be fixed by the registry. Yes, Ms. Butler, you are appearing in this matter.
Your Lordship.
Will you be filing your return as well?
No.
Lordship, in this matter, it's not required. The GS have. Like.
Fix a date, you are rather difficult here.
All right.
Fix a date.
Contractual bill.
Contractor's liability.
4 crore.
4 crore 15 lakh.
It's pending since when?
Since 22.
22.
22.
What?
And it is admitted, my lord. They have not denied, my lord. In RTI application, my lord, I filed and they replied.
Where is the admission?
Yes.
Paragraph?
Yes, my lord, they will find. And RTI page 25. Then their reply will be page 27. Master log bill submitted are duly certified and concerned divisional engineer found to be in order.
Para 25.
Page 27.
Page 20.
27.
Yes.
Thereafter, 5 bills were there, and each and every bills there are RTI reply, my lord, will find.
Yeah.
Thereafter, page 30.
Yeah.
Page 30 is also there in the last part. Past for rupees 1 crore 83 lakh.
Yes, ma'am.
Lordship, Mr. Esbora is appearing in this case. He's on legs. He's praying for 2 weeks time for
My
instruction.
lord, admitted it is, my lord, the direction may be passed for payment, my lord.
Today is the first time it has come after.
Not first time, my lord. Its notice was issued in March.
Correct, first time after notice.
Yes.
I heard Mr. J. Sharma, learned counsel for the petitioner. Also heard MS
J. Rajkumari.
J. Rajkumari, learned counsel appearing for GMC.
On behalf of Mr.
On behalf of S. Barua, learned standing
S.
counsel
Bora.
GMC. S. Barua. Bora, sorry, S. Bora. Okay, Miss MS so-and-so seeks how much time?
2 weeks.
2 weeks time to file return in the matter. A prayer is allowed. Relist after 2 weeks on a date to be fixed by the registry. It is needless to be clarified that since the issue involved in the writ petition is non-releasing of the contractual bill amount to the petitioner, which appears to be due since the year 2022, the return shall be positively filed by the next date of listing.
My lord, date may be fixed.
All right.
And next one is also same, my lord.
Next one is item number
33.
33 also same.
33 and 34 both are same.
33, 34. They are all 2022.
Yes.
Same, huh? Yes, Mr. Gogoi.
Names are not reflected otherwise.
Oh.
But I've been informed by my friend, my lord, appearing for the Panchayat department, that my lord, the finance has sought for some non-liability certificate. And accordingly, authentication certificate regarding the claim.
No, Mr. Gogoi, you see, authentication certificate and all this will go on.
My lord.
Now, the district commissioner's affidavit, it indicates, the instruction that has been given indicates that the funds have been, it is just waiting for funds.
Yes.
They say twice they had sent it to the PNRD. First time 2022.
Lots of.
PNRD is sitting over it.
Lots of.
Now 24 also it is sent. Now PNRD says that some authentication is required and all this.
My lord.
Now this court is really not concerned with all this, correct?
Lots of.
Now, if the work has been done, if you have
Yes,
been
it will have to be
verified,
paid.
it has to be paid. It is pending since
Some formalities,
2017.
my lord, yes.
2017, 2018. It's a,
My lord.
so you take a serious note of the matter.
My lord.
I'm posting, I am aware your name is not there, but since you are
Yes,
a
yes.
party, that is why
Lots of.
I have asked for you. I think you've been implemented as a party of respondent number 6 now.
Lots of.
You are respondent number 6. So you look into it. I'm having it next week, Friday.
Lots of.
Friday ki tarikh?
6th.
Next
week. Next week. Next week. Yeah, it will be 13th. 13th of June.
I'm giving you some time.
Lots of.
By that time, I want some positive direction, a positive instruction, sorry.
My lord.
I'm not.
Updated instruction I will place, my lord, and within the
See,
time frame.
if you can give us a time frame,
Yes,
we
yes.
will dispose it of.
Lots of. Yes.
Because it's are all admitted amounts.
Yes, my lord.
There's no point of hanging it, right?
My lord.
Heard Mr.
803.
So-and-so, learned counsel for the petitioner. Also heard Mr. S. Datta, learned counsel appearing for
PNRD.
PNRD. Mr. First you put B. Gogoi. B. Gogoi, learned additional advocate general, / also standing counsel finance.
Yes, ma'am.
Standing counsel finance. Then S. Datta, PNR, standing counsel PNRD, MS Udas, additional senior government advocate, MS.
And be on behalf of Rakesh Dubey, Assam State Election Commission.
Ma'am, please give your name for and also for the respondent. It appears that due to want of funds, the payments have not been yet released to the petitioner, which is pending since 2017 to 2018. Mr. B. Gogoi, learned additional advocate general, assures that within 10 days from today, he shall place the up-to-date status of the bills and also the time frame within which the aforesaid payments can be released to the petitioner. In view of the assurance made by Mr. B. Gogoi, learned additional advocate general, relist on Friday, not this Friday, next Friday. On such and such date.
Much of it.
Mr. Gogoi, try and sort it out.
Yes, better. I will.
If there is something, if it is not entitled, that's a
That's
different
it.
thing. But otherwise, it should not be pending for want of certificates.
Lordship,
These are your internal certificates. He doesn't have to do anything, isn't it?
Lordship.
Hello.
'27.
28, my lord.
Hmm?
28.
20.
28. But here the affidavit has been signed, my lord, but the annexures are not legible, so I could not file it. But
No
within this
problem.
we have filed it.
I just wanted to know that because on the last occasion you had taken time.
Yes, no, it's there with me. Holding.
Mr. B. Gogoi, Learned Additional Advocate General submits that though the affidavit is ready, however, the same could not be filed due to want of the legible annexures. Relist after
Next week, my lord.
relist on such and such date to enable so and so to file the return.
Lordship.
Lordship, in this case, I'm yet to receive the extra copy, Lordship. Yeah.
Why extra copy?
Nice.
Give it now.
Nice.
Give it. Heard, Mr.
T-Shake, my lord.
T-Shake, Learned Counsel for the petitioner, also heard Mr. S.R. Borua, Learned Government Advocate. Mr. Borua submits that the extra copies has not yet been furnished to his office, for which he has not been in a position to file return in the matter. In view of the aforesaid comma, let the extra copies as directed earlier by this court be furnished to Mr. Borua within
2 days, by
2 days from today. Relist after 3 weeks on a date to be fixed by the registry. Yes,
So
Mr.
this-
Dekka.
This matter pertains to non-payment of the contractual dues.
Non-payment of contractual bill.
Yes, my lord.
Since when?
1 year, my lord.
1 year. You are fortunate at least.
So to the tune of rupees 13 lakhs, my lord.
Yes, but even 1 year, it should not be kept pending. 13 lakhs, a
Various-
huge amount.
We
Yes,
have communicated to the department, but we are still awaiting.
for what?
As regards the claim of the petitioner, if he's.
Awaiting for the instruction.
Lordship.
Why instruction in such matters takes so much time? If they are not interested in sending instructions, we'll ask them to be personally present in the court.
Should we have?
These are
communicated-
contractual bill matters.
Lordship.
Right to livelihood of a person is at stake. Article 21 is involved.
Lordship.
It cannot be
Okay.
taken so casually. By when?
Lordship, 2 weeks.
No, not 2 weeks. Next week. I just want to know why the bill has not been paid. Is it admitted amount?
Yes, my lord.
Where?
In fact, my lord will come to para 10 of my writ petition, my lord. Page number 13.
Page
My lord,
number?
already para 10, page 13. 70% of the bill has been released, my lord. The remaining 30%, that amounts to rupees 13 lakhs, is yet to be paid, my lord.
The petitioner was entitled to a sum of 18 so and so for this and a sum of so and so for the out of which the respondent have made a payment of so and so. That's the total amount of so and so for word number. Heard Mr. A. Dekka, Learned Counsel for the petitioner, also heard
H. Bala,
MS H. Verwa, Learned Counsel appearing for
GMC.
GMC. Stop. It appears that the petitioner though the petitioner was entitled to a sum of rupees 18 lakh 6,700 gross for ward number 43 and a sum of rupees 18,86,796 gross for ward number 40, out of which the respondents have made a payment of rupees 11,35,849 towards ward number 40 and a sum of rupees 10,87,633 in respect of ward number 43. The balance, however, the balance amount of rupees 13,66,594 for ward number 40 and rupees 6,68,479.
My lord, that is the total. That is the total amount, my lord, 13,66,000.
However, a total amount of rupees 13,66,594 for ward number 40 and 43 is still pending. Stop. MS Barwa shall obtain instruction as why the aforesaid amount has still not been released to the petitioner till date. Has not been released to the petitioner. Relist on next week. Give me a date.
Lordship, 6
Six
would be
is
this
what?
week, Lordship.
6 to key day.
13th, Lordship. 13th.
Right. Okay, 6.
Lordship,
Very well. You want
No,
it
no, Lordship, I
Friday.
apologize.
I'm
Lordship,
happy to fix
13th.
it on Friday, Ms. Burwa.
Lordship, 13th.
13th. All right, give 13, huh? You have this instruction, and if it is made clear that if required, an affidavit is at liberty to place the instruction by way of an affidavit if so required. If you, because on that day, I will not going to give you time for filing reply.
No.
If you want to file a reply, you file it.
My lord, in this case, notices were issued on the last date, so there was a returnable date, my lord.
Yes. This is a land mutation.
Lordship, my lord.
Yes, Mr. Doctor.
My lord, we have appeared recently, my lord. We may be given
What
some
time?
to file our.
All right, Mr. Goswami, what about you?
We'll find out.
You will file. Heard Mr.
T. Chakraborty.
T. Chakraborty, learned counsel for the petitioner. Stop. Also heard Mr. S. Datta, learned senior counsel, assisted by Mr. Huh? S. Musahari, learned counsel for the respondent number
5 minutes.
5, and Mr. N. Goswami, learned
2, 3 and 4.
learned state counsel for respondent number 2,
3 and 4.
3 and 4. Mr. Datta as well as Mr. Goswami seeks 2 weeks' time to file their return in the matter. Prayer is allowed. Relist after 2 weeks on a date to be fixed by the registry.
There is an interim order, madam.
Interim, if any, shall continue to the next date of listing. Make it 3 weeks.
God bless.
3 weeks' time and 3 weeks listing.
Just for consideration of the interim prayer.
Blacklisting.
Also the interim prayer. Here, my lord, what happened, my lord?
What prayer, Mr. Sahewala?
Interim prayer.
Interim prayer.
My lord, what happened? The petitioner was the supplier of drug, my lord, manufacturer, supplier of drug. 3 years, my lord, contract was entered into with various manufacturers. Then some supply orders were placed. Petitioner, my lord, supplied more than 80%.
No, but on the last occasion, some instructions were called for.
Yes, my lord, they have, but here you will also see, my lord, but the point.
One second, Mr.
Lordship,
Sahewala.
we have received some instructions, but I believe it would be best given by addressed to the court by Counsel B. Gogoi. He's on legs,
By?
Lordship. Counsel B. Gogoi, Lordship.
Where is Bigo going?
He's on legs in court number 4, Lordship.
So we'll have it after
After some time,
then.
Lordship, Lordship. If it's all right. After some-
Once Mr. Bigogo is here, please inform Mr.
Lordship,
Sahewala
I
also.
will.
Mr. Sahewala, they'll inform
Yes,
you.
my lord.
$379 delay.
My lord.
No objection, please.
It's over. Nothing wrong.
Oh, this is civil.
828.
Suddenly it changed. That's why I was trying to reconnect. I'm like, what has happened? Yes.
They have filed, I filed this petition, application for condemnation delay.
of about 379 days. The reason is,
You want to file the delays in for filing the setting aside abatement.
no.
Then
Because they filed a suit was dismissed. Against they file appeal, the appeal allowed, and with against that order, we file an appeal after a lapse of about 379
this
days.
is against the RSA.
RSA.
Okay. Any objection?
My lord, what substitution has been filed, I do not know. Because
My
they
appeal
have,
is not admitted.
because there is a, two number has been given. Kindly see order dated 14/11/2022.
The learned counsel to the appellant submitted on the date of appellant number 30.
Now service is completed now.
Service,
Three
That is complete.
applications have been filed for condonation of delay, setting aside abatement and
Those
for
are
substitution.
allowed, already allowed.
Those are filing numbers.
Yes.
Third number is not available. The registry shall tag the said IAs on record. In the meantime, the learned counsel for the applicant shall take instructions regarding appellant number 8. No, these applications are still pending
No, all are disposed of.
because here it is all filing numbers.
No, RSA is filing number. Because there is a delay, that is why RSA has not been.
File for condonation of delay, comma, setting aside application abatement and for
For
substitution.
those petitions are already disposed.
Under filing serial numbers.
Those petitions are already disposed of. We also filed a amended cost title.
You have a look at it.
kindly see 14/11/2022 order.
I've
It will be
seen.
clear.
I've seen.
And then 39/2024.
Huh?
309/2024.
That order is not here. That order is passed in this IA. It's not here. 14/11/22 is there. Then 18/8/22, 25/5/22, 25/2/22, 2019/26, 20.
309/2024.
It's not here.
My lord, whatever here in this case.
What does it say? Read.
They are filing application for substitution of appellant number 26. So if it is allowed, I have no objection, my lord. But the
according
petition is to be there, my lord.
That was already, my lord,
According to him, it's already allowed.
allowed.
You do one thing, mister, you give him all the copies.
Now we already have copy hit to
He
them,
doesn't
my lord.
know.
We already done, before filing, we,
Confusion. He has a right to.
yes,
do-
my- before filing, we supplied them the copy, my lord. Matter has come. The order has been passed in presence of them, my lord. All the IA has been disposed of. Now remain two IAs here. That is for condonation of delay.
And the second one?
Second one, 422, I filed an applications for stay of the execution proceeding. 24227. Those two petitions are pending now. And some petition I withdrawn because we are not.
With objection.
Mr. Ghosh, you have a look at it.
My lord, we have in the delay condonation original application.
Yes, that was.
We have already filed objection.
That
We
will
have
be heard.
already filed objection.
That will be
Can
heard.
I take that up now?
Yes, yes.
What is your objection? 379 days.
Objection is that, my lord, the decree has already been executed. There is nothing survived.
Degree is already executed.
Yes.
So third party rights have been.
No. Executed and the record has been already been corrected in favor of the.
Yes, your explanation of delay.
Delay is no, execution is not there, my lord.
Delay
There is-
explanation.
Paragraph 4, my lord. No, paragraph 3, my lord. And my friend submitted execution has no execution has been carried out till date because the learned court will also pass an interim order. This is the order. my lord.
Which issue? 26. সিহঁতে পাছ কৰা নাই এবাৰতে
Otherwise, paragraph 3 is sufficient, Mr. Ghosh.
My lord, kindly see.
Their advocate did not inform,
Yes.
for which they didn't know, they were otherwise meeting him. Suddenly, when the measure, they went upon the execution filed, when measurements started being taken, that time they came to know.
Before passing in execution order 23/12/2019, kindly see the order.
Sure.
Executing court.
What is this, Mr. Ahmed?
This was order passed in the execution case number, my lord. Execution case. No execution has been carried. The London court will stop the proceeding, my lord.
Kindly see the order, my lord.
This is of 2/3/24. Which
First-
order?
Stop. Yes.
23/12/19.
Yes.
Something is wrong. You get me the up-to-date status.
Up to date after passing of this order, my lord.
Because 2/3/24 order says, I have perused the order passed by the Honorable Guwahati High Court. Though there is no specific order of stay of execution proceeding, but since appeal is preferred before the High Court, I am of the opinion that at this stage, if decree is executed, the purpose of second appeal will be frustrated. Hence, the instant execution proceeding is stayed until further
Yes.
orders.
It is that stage, my lord.
So it is stayed.
State, kindly see that order, my lord. From that order, there are two parts of the decree, my lord.
So then some
One
part of the decree is
has
stayed.
been, some part, yes, there are two parts of the decree. One part is correction. Correction part has already been done in favor of this respondent. And so far is possession part, measurement part is remain there only.
Then with all fairness, these are condonation application. Why should this court foreclose it? This court has to be liberal unless and until, of course, the grounds are not absolutely not sufficient or not bona fide. That is not your grounds about bona fide. These explained.
Our objection is there, it may be reported, kindly see. And apart from that, the appeal has already been abated because appeal number
They will come, appeal is not yet
26
number.
has not yet been substituted. So appeal abates.
Against him also, no others.
Whatever
Only
it
one
is.
appellant can file a bill, my lord.
That I will show.
26 is not
All
necessary.
right.
my lord.
Heard Mr. J. Ahmed, learned counsel for the applicant. Stop. Also heard Mr. S.K. Na?
Yes.
S.K. Ghosh, learned counsel appearing for the
Respondent number 1.
respondent number 1. Stop. By way of this application, the applicant is seeking condonation of delay of 379 days in filing the connected regular second appeal against the judgment and decree passed by Civil Judge Morigao entitled Appeal number 15 of 2016 on 28/2/2018. Stop. The brief facts of the case is that the respondent number 1 as plaintiff had filed a suit in the court of the Munsif number 1 Morigao, being title suit number 30 of 2011 against the applicants and other respondents contending inter alia that Haji Ismail Khan, since deceased, had 5 sons and 2 daughters through first wife and 2 sons from second wife. The wife predeceased the children. Out of the son of second wife died unmarried. The respondent number 1 claimed his share to that of 12 bigha 4 katha 14 lechas by virtue of inheritance. from his father and unmarried brother. The respondent number 1 further purchased 2 katha, 18.5 lecha of dag number 192 and 3 katha, 10 lechas of dag number 298. From Nurul Islam, PDA registered sale deed number 2116 dated 3/11/1989. Stop. The heir of Yaqub Ali filed a suit being titled suit number 12 of 2004 against the respondent number 1 and others, which was decreed, and on appeal, the judgment and decree was set aside and remanded. As the right, title, and interest of the respondent number 1 was clouded, the instant suit was filed on the prayer mentioned above. Was filed. The learned trial court by judgment dated 21/3/2016 dismissed the suit on the grounds that the respondent number 1 failed to prove the execution of the sale deed and failed to prove that out of 8 shares, the respondent number 1 is entitled to 2 shares. The plaintiff stroke respondent number 1 filed appeal being titled appeal number 15 of 2015, and the first appellate court reversed the findings of the trial court on the ground that the respondent number 1 able to prove the execution of the sale deeds, and accordingly the matter was remanded to the trial court. Correct? That is correct, na?
No,
Matter was on remand.
no, no, my lord.
Huh?
No, my lord. Against that will come.
Against which you have come.
Against the appellate order, my lord.
All right, all right. Situated thus, the present second appeal has been filed. However, while filing the present second appeal, there has been a delay of 373 days. Stop. As such, the present condonation application, correct?
Sounds correct, my lord. Title suit was dismissed. Then in appeal,
Appeal allowed.
Reverse,
Appeal allowed, yes.
allowed and
allowed
reversed,
and decreed.
Decree, not return, not remand.
not remand.
No.
Not remand, decree.
Decree.
In favor of the plaintiff.
Okay, then you say in the appellate court, now you say reversed and decreed in favor of respondent
Plaintiff.
number 1.
Yes,
Plaintiff.
plaintiff responding.
Okay. Then situated thus the appeal, second appeal. Okay. Mr. Ahmed, learned counsel for the petition applicant submits that the delay has been occasioned in as occasion for having for want of knowledge as regards the judgment and order in as regards the appellate court's judgment and order
28 to 2018.
and
Not informed by the council.
upon being not informed by the engaged counsel, and it was only when the who had come to measure it was only in the end of March 2019 when the respondent had come to measure the length, he had the applicant had learned about the same. Mr. Ghosh, learned counsel for the, on the other hand, Mr. Ghosh, so and so, vehemently opposes the prayer of condonation and submits that, where is the objection?
Page 2, kindly see, para 3. Page 2. 3A and 3B. Affidavit in opposition.
No, affidavit is.
It will be in IA, my lord. 3568.
Is it this? I don't know. The time it is.
Affidavit filed by the appellant. No. You have a copy?
Yes.
Just give me a copy. Admits that the Lahori Ghat Revenue Circle has already partitioned the scheduled part of the land by giving different dags and pattas over the respective scheduled lengths. And that no sufficient cause has been shown for the delay of 379 days, except the blame made upon the engaged counsel,
Who was not made party.
who was not even made a party in the condemnation application. Stop. Heard, perused, huh? Apt to refer to the grounds taken for in support of the condonation prayer, quote unquote, paragraph page 13, paragraph 3. Okay. It appears that though the applicant was, it appears that the applicant has by engaging a counsel has filed. You had filed the first appeal. No, they had filed. Has contested the first appeal preferred by the respondent number 1. However, since it further appears that later on that though the applicant had initially been in touch with the said engaged counsel, however, later on, having appointed the learned counsel, was of the impression that the learned counsel would inform the applicant as regards the development of the case. It was only in the end of March 2019 when the respondents had come to measure the disputed suit length. The applicant came to know about the passing of the judgment and decree dated 28/2/2018 by the First Appellate Court. Undoubtedly, the applicant is not required to act as a watchdog of the advocate. The power of condonation is discretionary, which is condition precedent of existence of sufficient cause. The grounds averred in the condonation application appears to be sufficient and bona fide. The argument of Mr. Ghosh as regards the partition being carried out
And suit is a partition suit.
in respect of the argument. Mr. Ahmed places the certified copy of the order dated 2/3/2024 passed by the Civil Judge Junior Division number 1, Morigao, in connection with title execution case number 4 of 2019. A perusal of which indicates that though there was no specific order of stay. However, since the second appeal is pending, the execution court deemed appropriate not to proceed with the not to further proceed with the execution proceeding. Stop. A copy of this is, you say a copy of the order dated so and so, placed by so and so is kept on record. In view of the fact that this court is satisfied that the grounds averred are sufficient and bona fide, comma, this court, in the interest of justice, deems appropriate to condone the delay of so and so days. Accordingly, the delay stands condoned. Delay application allowed. RSA is registered?
No,
And the registry registered the connected RSA and placed the same before the court.
And second, appeal maybe served.
They will
Can I?
disposed of.
I'm sorry, Malat, I done Lakes in court number 11.
No more problem, Mr. Parashar.
Malat, here, Malat, I am appearing for response number 123 railway, Malat.
20. This is
27. 27, Malat. I have actually not received the detailed instruction. I am appearing for railway, Malat. Now, from state government, Malat, they have informed that some land is excessively under the position of railway, Malat, without any proceeding. Malat, regarding that, Malat, I'll take instruction, Malat, from the railway authority, Malat. And in 3 weeks time, Malat.
How much?
3 weeks time before vacation, Malat, maybe.
Why don't you both take, Mr. Goswami, you want to file anything?
Yes, we'll handle it.
As prayed for by Mr. K.K. Parashar, Learned Standing Council,
CGC for
Learned CGC, and Mr. N. Goswami, Learned State Council, relist after 3 weeks to enable these respondents file return in the matter. On a date to be fixed by the registry, huh? Yes.
So, Lordship, matter relating to SKC benefit, Lordship, it was filed on in the year of 2010, Lordship. Then thereafter, Lordship, authority has prepared a sanction amounting to rupees 2 lakhs, Lordship. But this case was filed in the year of 2020, Lordship. Then thereafter, authority has asked me to submit the NOK, Lordship, for preparing and sanction the said amount.
Submit what?
NOK, next of kin certificate.
Yes.
Accordingly, I have submitted the NOK, Lordship. Then thereafter, Lordship, authority has already issued a sanction letter, but same was not available with me. Only because of that, Lordship, police was directed to verify my local address, Lordship. At the time of filing, Lordship, my address was in Guwahati, Lordship. Then thereafter, I was shifted the same address from here to Lakhimpur, Lordship. That is why, Lordship, sanction order was not released, Lordship.
What is
That
to be
is the
done?
typical.
Revenue Department also has requested Deputy Commissioner of Dima Hasao and Kamruk Metro to provide the sanction order.
Already sanction has been made as from Lordship. Sanction was not.
Then why sanction has not been given? Where, who is appearing for Dima Hasao? Deputy Commissioner Dima Hasao?
I can appeal this.
Yes. Sanction. When are you going to sanction?
I have to take instruction, Lordship, because
Friday.
Lordship.
Heard Mr. M. Saikia, Learned Counsel for the petitioner. Stop. Also heard Mr. N. Goswami, Learned State Counsel, Learned Government Counsel for the state respondent, and MS N. Borderloy, Learned Standing Counsel, Revenue. MS Borderloy submits on instruction that, yes, please tell me your instruction.
From the Revenue Department, the Deputy Commissioner Dima Hasao as well as Deputy Commissioner Kamruk Metro has been requested to kindly furnish the details of the sanction order, Your Lordship, in respect of the person who has died.
Has requested the District Commissioner Dima Hasao and
District Commissioner Kamruk Metro.
District Commissioner Kamrup Metro to furnish the
details regarding the
details
sanction order
regarding the sanction order
in respect of the
in
deceased person.
respect of the
Deceased person. late-
deceased person in
late Kapu
connection with
Bora.
the aforesaid case.
Yes.
Correct?
Yes.
Stop.
No.
Yes, Mr. Goswami?
No,
Mr. Goswami seeks a short accommodation
Friday, Lord.
to obtain instruction in this regard. Relist on Friday, such and such date.
Your Lord.
Understood.
Lordship, I may be allowed to take steps upon the respondent number 2. If only my humble prayer is the Lordship, the order passed by this honorable court on 3/3/2025. That is not uploaded in the Lordship online. Therefore, Lordship, difficulty cause only.
Which order?
3/3/2025.
Huh?
3/3/2025. Only order passed in interlocutory obligation that has been uploaded both in interlocutory as well as Lordship in
Why is this
main
not
contempt.
upload per an every person?
Upload.
It will be upload on the same
Lordship,
day.
it
कोई
is
double
up-
order? Huh?
uploaded, but Lordship, the order passed in interlocutory application that has been uploaded. But
You go speak with the registry.
yes, Your Lordship.
You cannot come before this court with all these complaints. Further, you are not taking steps. If you are there is any difficulty for you to take steps, you file an application before the registry.
Yes, Your Lordship.
Why are you not doing that?
I may
How
be
will
allowed-
this court look into all these issues?
Yes, Your Lordship.
Go to the registry.
Yes.
How much time you need for fresh for taking the steps?
3 days, Lordship.
And you can also obtain a certified copy if you want. Mr.
D. Sharma.
B. Sharma, learned counsel for the petitioner, seeks assures that the steps as directed earlier by this court shall be taken within a period of 3 days from today. In view of the aforesaid assurance, relist after 2 weeks on a date to be fixed by the registry.
Highly obliged.
Then appears for the petitioner on call, list on Friday with the remark for dismissal.
Hello, please.
6.
Yes, Mr. Goswami.
That was the Lordship.
Step.
Well, the matter has come from the Lawazima court. Actually, what has happened, in spite of our best efforts, we haven't been able to serve only respondent number 6, who is the main respondent here, my lord.
Respondent number 6.
6, my lord. Now, my lord, an order was passed on 27th of May,
Yes.
this month, my lord. Before the,
Lawazima court.
yes, Lawazima court, my lord. That may kindly be seen once.
The instant matter has been carefully perused, and upon such perusal, it has been discovered that the petitioner was directed by the previous Lawazima court or refusal to obtain proper instruction regarding the address R6. However, in regard to the respondent number 6, the so and so submitted and had already preferred, which is pending, and so has been represented by her legal counsel. You want to take it through
The council, well, I'm not naming him, my lord, but they are both the parties are represented in that suit. So if your lordship passes an order for Dusty, my lord, through him, my lord.
Mr. B.D. Goswami, learned counsel appearing for the petitioner. Stop. This is what I read petition.
Every petition, man.
Because I'm clubbed with writ petitions and RSA. So
My lord, my lord, my lord. Very difficult.
very difficult.
The
For the RSAs, we can have an allotted day.
RSA by itself is very difficult, man.
Office note dated 27/5/2025 indicates that due to complete due to full information as regards the address of respondent number 6, the notice could not be effectuated. Mr. B.D. Goswami, learned counsel appearing for the petitioner, submits that since the respondent number 6 has preferred a title suit bearing PS number 6 of 2019 before the learned Munsif number 1 Kamrup M against the writ petitioner, which is pending for disposal. The issue there also is similar.
Slightly different.
In connection with a similar issue involved in the writ petition, comma, he may be allowed to take steps upon the respondent number 6 through her engaged counsel, who is presently conducting her case before the learned trial. Stop. Prayer is allowed. Let notice be served through the engaged counsel of respondent number 6. When is the next date?
In that suit, my lord. On that, my lord, I cannot give the date, but I can furnish.
On the next date.
On
the next date before the trial court.
Well,
And an affidavit of service to the said effect be filed along with the receipt in support of the service. List after 2 weeks on a date to be fixed by the regulator.
it will be subject to, my lord, the next date in that suit, my lord. Your lordship, without mentioning 2 weeks, thereafter the.
All right.
Yes.
In that.
Much obliged.
Only thing is that, you see, it becomes very difficult. We don't know whether that advocate is there. So if the things happens on the next date and you show this order, probably the trial court will also do a recording in the order sheet. If it happens.
That court.
Yes, yes. Because that is.
My lord, if your lordship mentions by dusty, my lord, that will, my lord, mean I can take a notice from the registry itself here.
By dusty.
By dusty.
By dusty.
In that case, my lord, the court recording will not be necessary.
Okay, by dusty and we will to
True,
Nukoba, next date to Nukoba. Through dusty.
My lord. Much obliged.
You can ask your junior to just have a look after the order is typed out.
I will.
May I please, your lordship? My lord, kindly peruse the order dated 28/5/2025.
Yes, last chance. Where is the contemner?
Orally taken. Orally. Lordship, in this matter, with due apology, Lordship, although I have not filed any affidavit, but the matter has been complied with, Lordship. If Lordship comes to the impugned order, Lordship. Paragraph 7, Lordship. Please. Page 26, Lordship.
Yes.
Paragraph 7, Lordship.
Yes.
Having considered the contents of the said order dated so and so and the decision of the full bench judgment of this court rendered in 29/9/2000 in writ appeal number so and so, Tamsir Ali and others by State of Assam, and similar others 194 writ petitions reporting so and so, it is considered appropriate that the respondent authorities in the respondent BTC shall undertake a complete similar kind of exercise like the one mentioned in the order dated 15/11/2021 in respect of the claim of the petitioner, also within a period of 3 months, if after such exercise the petitioner is found entitled to the amount of rupees 18,80,069 as claimed herein, or any other amount, the same shall be released in favor of the petitioner in terms of the decision in Tamsir Ali. So in the meantime, Lordship, that list has been prepared, Lordship, by following the full bench judgment, Lordship, and his position is at serial number 100, Lordship. The moment the person at serial number 99 is paid, Lordship, next due shall be.
But Mr. Nayak, the affidavit has not been filed.
Lordship, I have already forwarded the copy to the.
The order of this court is very clear.
Yes.
By way of a last chance, the matter is posted on 2/6/25 to enable the contemner to file his reply in the matter, failing which he shall remain personally present in the court on the next date of listing.
Yes, sir.
Is he here?
That's how somehow
Is he
Lordship
here?
is not here.
Well,
That for that Lordship, I am only apologizing, Lordship.
that's not
But-
correct.
But in that judgment, Lordship was
That's
observation.
not correct, Mr. Nayak.
Yes, Lordship.
The judicial orders of these courts are not being respected. Lordship. It is a very dangerous position.
Then
It is a
Lordship.
very dangerous position.
Yes, Lordship. On next date, Lordship, I'll definitely ask him to remain present before the court, Lordship. And in the meantime, I'll file my
Friday,
affidavit. Lordship,
Friday,
Friday,
Wednesday.
Wednesday.
Today is Monday, no? Wednesday.
In the meantime, Lordship, I'll file my affidavit.
You file it.
Lordship.
You file it. Otherwise, this cannot go on like this.
Yes, Lordship. I apologize for that, Lordship. Somehow I missed this order.
Like this.
One of my colleague was appearing, Lordship. Somehow I missed this order, Lordship.
It's not fair. It's
Yeah.
not fair to the court.
I admit, Lordship.
First of all, orders are not complied. Then instructions are placed before the court without any without any apologies. When this court says you file, failing which you be present, then
Yes.
despite that kind of a judicial order, officer shows no respect.
I
This
apologize.
is
Lordship.
really bad. It cannot go on like this. Cause it is actually a threat to the very existence of the institution.
I
If
admit,
this is the manner in which
Yes.
the orders of these courts are being treated,
Lordship, Lordship.
it cannot go on like this. Absolutely not.
It will not happen next time, Lordship. I assure you, Lordship. But on last date, Lordship, an
Yes, I
impression,
have seen that on the last date, you were
Yes.
not there.
one
On
impression,
behalf of you, someone was.
Lordship. Lordship, one impression was tried to be given, Lordship, that the order has not been complied. In fact, petitioner is aware, Lordship, that his position has been,
Whatever
Dear.
be it,
yes, Lordship.
Mr. Nayak, you have to understand that this is a contempt petition.
Lordship.
This is not a writ petition.
Lordship, I admit,
You
Lordship.
see, if it
it's-
was a
I-
writ petition, it's a different thing. The moment it is a contempt petition, your responsibility doubles up.
Yes,
Because the allegation is about non-complying of the court's order. Yes, you may have complied, but it is you who know it. This court doesn't know it.
yes, Lordship.
There is no affidavit before this court. How will this court know that the order of the court has been duly complied?
Lordship, I once again.
Despite chances
yes.
being given, the affidavits are not coming. You see, you understand?
Yes, Lordship, definitely. Lordship, I apologize for that, Lordship. Lordship will grant me one last opportunity in the
Mr. P.
meantime.
Nayak, learned counsel appearing on behalf of the contemner, submits that due to a misunderstanding of the last court's order, despite the affidavit could not be filed today, the contemner is not being able to personally present in the court. He, however, assures that the affidavit shall be filed
Today is Monday, Lordship. By Thursday, Lordship, I'll find it.
by Thursday, and
If required, that person will
And if
remain
required,
present.
the contemner shall also remain present on the next date of listing. It is regrettable that despite judicial orders being passed, the same is not being given the respect and honor. However, without taking any adverse step today, in view of the assurance made by Mr. P. Nayak, learned counsel appearing for the contemner, this court, by way of this court, what is the use of saying by way of last chance? this court post the matter on Friday, such and such date, to enable the contemner to file the affidavit as directed earlier. Failing which, don't say failing, stop for. It is needless to be clarified that if the affidavit as directed by this court is not filed by the next date of listing, adverse orders against the contemners, including issue of warrant of arrest if required, shall be issued on the next date of listing.
I apologize. I really apologize.
Okay.
Yes, Mr. Barpujari.
My lord, here, my lord, I am appearing on behalf of R1. We have already filed an affidavit, my lord. I am seeking some further indulgence of my lord, to file an additional affidavit to bring on record, my lord, the exercise of compliance that has been undertaken by the respondent.
How much time?
3 weeks time, my lord.
For last few occasions, the same submission has been made by the authorities. The direction was issued.
1 week.
1 week.
1 week. And I'll make it clear, in 1 week, if you don't file what you want to file, then you will have your officer in court.
Absolutely.
Heard Mr.
And Sharma.
And Sharma, the counsel for the petitioner, also heard Mr. R. Barpujari, learned counsel appearing for
Respondent 1.
Contemner number 1. Mr. Barpujari, learned counsel for the contemner number 1, submits that
it is at the verge of, my lord, complete compliance.
Submits that seeks a short accommodation to place an affidavit to place the up-to-date status as regards the compliance. In view of the relist after a week on a date to be fixed by the registry, give a date after a week. List on such and such date.
11 June. In the meantime, my lord, I will file an additional affidavit.
It is needless to be clarified that an affidavit, if required, it is needless to be clarified that the contemner is at liberty to file additional affidavit, if so advised, to bring the compliance on record. Correct?
If order is not complied, that observation.
That I cannot say if not ordered. I have not heard the matter. Let us first see. You place it. It is, however, made clear that if the affidavit is not filed, you file it within 1 week.
Absolutely, my lord. It
is, however, made it clear that no further charge for place shall be given to the contemner in this regard.
I'm so obliged, my lord.
May please, Lordship. Lordship, again, this is a RSA Lordship. And in this case, Lordship, we have filed one IA for repairing our house, Lordship, which has been damaged. Lordship will take up the IA 2739 of 23.
2729.
Sorry, Lordship.
2739.
Yes, Lordship.
Yes.
Lordship, Lordship may peruse page 11, the photograph of the rice mill, Lordship, which is the only source of my livelihood, Lordship. It is almost damaged, Lordship. So I am seeking some only to repair the rice mill, Lordship. Permission from this honorable court, Lordship.
Lordship, for the appellant, Lordship. In this case, Lordship, when the rice mill, which is they want to repair, Lordship, it's within the very land of the disputed land, Lordship. If this honorable court allow them to repair the same, they will change the nature and feature of the suit land, Lordship. This is the only concern, Lordship.
Who is in possession of the rice mill now?
What?
They are in possession.
Yes, Lordship.
They are in possession.
We are in possession, Lordship.
But after filing this appeal, Lordship,
You have filed any objection?
no,
Lordship,
Lordship.
on
No
T
written
one,
objection has been filed.
Huh?
I tried to contact the appellant, Lordship, but probably he changed his mobile number, Lordship. I could not contact him.
You filed your objection?
Lordship, on T1 2025, they sought time to.
I have seen,
Yes,
but let them file their objection.
Yes, Lordship.
How much time?
Last
2 weeks, Lordship.
Mr. So-and-so Chaudhary,
Yes.
learned counsel appearing for the respondent seeks 2 weeks' time to file objection in the matter. By way of a last chance, the prayer is allowed, list after 2 weeks on a date to be fixed by the registry.
And Lordship, in the RSA, Lordship, Lordship, kindly peruse office note dated 17/12/2023, Lordship.
Office note?
17/12/2023, Lordship.
$27,500 is the last.
Lordship, earlier than that, Lordship, there is a office note of office
Because
note.
27 says no fresh step has been received for issuance of notice upon R18 till date.
Yes, Lordship,
Neither
and
AD card nor any and so and so and so further. But today RSA is not listed.
along with the ISA, Lordship, RSA is also listed, Lordship.
It is attached.
Yes, Lordship. Yeah,
Which order you want to show?
As per office note, Lordship, the some of the respondents has died, Lordship. The substitution has not yet been filed. And
But you do whatever you have to do. You don't need any orders from here.
Lordship,
But,
I'm the respondent, Lordship.
You are the respondent.
Yes,
You are
The
appellant.
appellant, Lordship.
Hey, today he is not asking
Yeah.
for all this.
Yes, Lordship.
Lordship, the interim order passed on 24/6/5/2021 in IA, Lordship.
RSA.
IA, Lordship.
What I?
IA number
No, but in the
2465.
RSA, Mr. Counsel, why have you not taken steps?
Step has been taken, Lordship, but subsequently office note.
R18, no fresh steps has been received for issuance of notice upon R18. This is the office note, 27 May 25. You take all this, we are not going to give you interim, we are not taking steps. What interim you want?
No, in the IA, Lordship.
No, why should I this court extend the interim when you're not taking steps?
No, we have already taken step, all the
The
respondent,
office
Lordship.
note says you have not.
Because the,
Office note says you have not.
yes, some respondent has already expired, Lordship, and
You
the,
do whatever is to be done, you're not doing it. Nothing. Order
IA for the stay of the execution, Lordship.
Nothing.
And there is an order for.
Today, right now, only IA 2739 is before this court. The rest are only with it. So if you want, then you immediately take steps. Thereafter, when it comes, this court will extend it.
Lordship, in that case, I may be allowed to take steps for paper publication, Lordship,
No, no,
because the
no, nothing doing.
legal
You
ad,
file an appropriate application.
Lordship.
Next case.
Obliged, Lordship.
My lord,
RSA.
yes, from office it appears that some have been served, some have refused, and some are returned without service.
Some are
So
returned.
returned.
You want to take fresh steps?
Some have refused. No, today we have on, it is office note dated 25, 20.
Yes, I have
Right.
seen.
So,
So
so
what is
now
to
we
be
will
done?
take fresh step upon the unsubscribed respondents.
As prayed for by Mr. So-and-so Mahmood, learned counsel for the appellant, list after 2 weeks to enable these, Mr. Mahmood, learned counsel for the appellant, seeks 2 weeks, submits that fresh steps in respect of the unserved respondent shall be taken, shall be allowed to be taken.
Some have refused, so that may be presumed as served.
That we will see on that day. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry. It appears that the case report has already been received, which is connected, which is tagged and connected with the second appeal.
Please, your lordship. Lord, as per office note dated 21/5/25, my lord.
Yes.
The respondent number 1 and respondent number 5 have not been served, my lord, because they were not found.
one was not served because there was no ward number given, and my lord, respondent number 5 is the mother of 6 and 7.
Not found, R5 not found.
Yes, my lord, 6 and 7.
One could not be served as word number is not mentioned.
Where will the,
2 is served personally, 3 is served.
who is the mother of 3 and 4?
Mother. 3
And,
4.
5 is the mother of 6 and 7. However, for 6 and 7, aunt has received, and it is stated that they don't know where their mother is. So, my lord,
But still, what is to be done then?
my lord will take fresh steps. As regards 1 and 5 is concerned, my lord.
Mr. A. Batra.
A Bhatra.
Huh?
A Bhatra, Aditya.
Sorry?
Aditya Bhatra. A.
A.
Yes.
Batra, right?
Yes.
BATRA.
BHATR.
Acha. Learned Counsel for the petitioner, sorry, not petitioner, appellant, submits that fresh steps may be allowed to be taken in respect of respondent number 1 and respondent number 5 as service could not be effectuated against the aforesaid respondents. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry.
My lord, as regards the I is concerned, my lord, the interim order has to be extended, my lord.
Which I?
My lord, the connection. Filed with the appeal for stay.
2729.
272920. Lord, interim order dated 9924.
The IA 2721 interim passed earlier shall continue till the next date of listing.
Highly open.
May it please the lawsuit. My lord, here in this case, the appellant number 1 died. So there was some delay, my lord. We have filed a substitution petition with the application for condonation of delay. Now, my learned friend has received, opposite side has received the copy, my lord. They have no
254 days.
objection in the matter of substitution, my lord.
254 days delay.
No, my lord, 257 days.
257 days.
Yes.
IA 220 is the condonation.
Yes, condonation, my lord.
Yes, any objection, condonation.
No, your lordship.
Otherwise also, my lord, I have an instruction, the matter is supposed to be closed because they are coming to amicable settlement.
So should we keep this pending?
Perhaps they are required to file.
So should we keep this pending, the condonation, or you want the delay to
Of
be
course,
condoned?
after this condemnation is over, my lord, then they will come up with
So you want
application.
me to condone or you want me to keep it
No.
pending?
No, my lord. To condone and to allow the substitution.
Heard Mr. M.H. Rajparbhuya, Learned Counsel for the applicant. Stop. Also heard MS?
Mrs. S. Acharji,
S. Asarji.
on behalf of
behalf of
Mr.
J.
J.
Das.
Das.
Learned Counsel appearing on behalf of Mr. J. Das, Learned Counsel for the respondent. Stop. By way of this application under Section 5 of the Limitation Act 1963, read with order CPC, Limitation Act, comma. Present application is filed for condoning the delay of 257 days
Yes, ma'am.
in filing the connected regular second appeal. Stop. It appears that during the pendency of the second appeal,
Yes, ma'am. Appellant number 1 died.
the appellant number 1 died, expired. And since no substitution application was filed due to want of knowledge as regards the death of the appellant number 1, comma, the appeal got abated after the expiry of the statutory period. Hence, an application for setting aside the abatement of the appeal in respect of the deceased appellant number 1, as well as an application for substitution of the legal layers of the appellant number 1 has been filed.
Yes.
However, there has been a delay of 200, or there has
57
been
days.
a delay of 257 days while filing the aforesaid application.
Exactly.
Accordingly, the present condemnation application has been filed. Mr. So-and-so, learned counsel for the applicant, submits that the delay has been occasioned for no fault of the applicant. Purely because of, no fault, stop. And MS so-and-so submits that she has received no instructions to oppose the prayer for condonation. Stop. Heard, perused. Apt to refer to paragraph P 4. No, sorry, paragraph 5, page 5. 5. Where are the grounds averred?
My lord, ground refer, my lord, your lordship may please to see a flag, my lord. There is an affidavit, additional affidavit we have filed. It brings out the entire matter clear, because there was initially some mistake which has been rectified for court's order.
So where are the grounds mentioned?
My ground mentioned, my lord, in my application under and number 220, my lord, paragraph 2-3 may kindly be seen, my lord. Of course, there is some mistake in calculating the date.
Apt to refer to paragraph 2, 3, 4, 5, 6. Further, it appears that there has been, and further it appears that by way of an additional affidavit, in terms of the direction given by this court by order dated 27/2/2025, the applicant has clarified as under paragraph page 44, paragraph 1 of 4. 1 of 3. Reading of the aforesaid averment, it appears that the grounds pleaded for in support of the condonation prayer is bona fide and sufficient. That being so, the delay is condoned. The substitution and abatement applications are there.
Yes, my lord.
They've been numbered.
As many as 3 applications.
Numbered.
Yes, these are numbered. My lord, application number 221. 221, my lord, application for substitution. And application 199 is for setting aside abatement.
Abatement is which one?
Yes, 1999.
IA 199 to Ludwig. Parties will sub ekey thakibo. The by way of the instant application, the applicant is seeking setting aside of the abatement in respect setting aside the abatement on the death of the appellant number 1 who expired on 31/8/2022. The brief facts of the case is that the appellant number 1 during the pendency of the appeal expired, leaving behind his legal heirs. However, due to want of knowledge, the substitution could not be preferred on within the statutory time period for which the appeal got abated automatically against appellant number 1.
Yes.
Accordingly, the abatement, setting aside of the aforesaid abatement against the appellant number 1 is being filed. It appears that the appellant number 1 has left behind his legal heirs a paragraph 8 dot, page 8 dot Paba A to A. It appears that the appellant number 1, i.e. Abdul Malik, who expired on 31/8/2022, has left behind his legal heirs who are as under code A to A, page 8. The aforesaid they are all their children.
Yes, my lord. Wife and two.
The aforesaid legal heirs, being the wife and children of the appellant number 1, have a right has a right to be be replaced in the place of appellant number 1. As such, the substitution as such the setting aside of abatement against the appellant number 1 stands cancelled and set aside. Application stands allowed. Next, 221. Etu অকমান similar ধৰণৰ খালি ইয়াত substitute কৰি দিবা abatementor শব্দত এটা substitution হ'ব পাৰিবা substitution এই দুটা এটা period পাই যাবা. So application for substitution of the legal heirs of the appellant number 1, and এটা জায়গাত যে তলত আছে তাক ক'বা the appellant number 1 হে যে মই ক'লো who died so and so, leaving behind the legal heirs who are as under list continue. Accordingly, it is essential that they be substituted, allowed. Last thought, it is accordingly provided a prayer portion to so and so be substituted in the place of substance.
Much obliged.
Disposed of. Into kiman number is here? 50?
Ma'am.
38. Yes, this is
Hello.
that blacklisting.
My lord, blacklisting, my lord. May I place the fact, my lord? If your lordship will see, my lord, we supplied more than 80% of the medicines which we have ordered to. For some medicines, my lord, these were already
For what?
medicines.
Medicines.
These were given to transporter, but transporter has made some delay, my lord, in supplying the medicine. Yes. So on 94, page 94, your lordship will see, my lord, we have submitted earlier an application for extension of 15 days time. So they have issued a letter to us.
Yes.
With reference to a letter so and so requesting for extension of delivery period and of 25 number of POs mentioning the item details where so and so highest financial penalty 2% per week maximum is already over and extended delivery period is over. Therefore, you are directed as directed. I am to inform you that against every PO for which you have requested for extension should also include the item name and tentative date of supply from your end. Kindly resubmit your extension request by tomorrow, mentioning the above information for honor submission to so and so and so. So, my lord, this is a letter, if your lordship find it is 10 February 25. We are asked to submit again this, my lord, letter by next day. Next day we have submitted, my lord, same day, 10 February 95 page. Page 95, my lord, giving all the details of the medicines which we have to supply, my lord.
You have submitted.
We have submitted, we have paid for 15 days time as a special case.
Huh?
15 days time.
What 15 days? Extension.
My lord, extension, yes. For 15 day extension. This is the letter, my lord. But on this, my lord, no order has been passed.
Yes.
After this, my lord, they have directly issued a so-called notice, page 97.
Extension or not extension, Mr. Gogoi?
My lord?
My lord, multiple times, my lord, extension have been granted, my lord. I have
Look,
looked at
after
that.
this, on 10/2/2025,
My
they
lord.
had sought for an extension.
Yes.
But you have said, no, you give us the information on the next day.
Yes.
On the next date, they had given the extension.
Same day, my lord, we have
Now,
given.
what's happened to that? Because after this, show cause notice has been given.
Yes.
Yes.
And so-called notice.
One
we have-
second, Mr. Sahawal. Because right now it is for interim order.
Yes.
My lord, exactly, my lord, after 10th of February, what has happened, my lord?
No, but that is what is important because Mr. Sahawal's entire case is that you have not given the extension, instead you have directly show cause them.
No, it's not regarding one item, my lord. Multiple orders were issued. All along, my lord.
Where is the show cause?
Yes, lordship will see,
My
my
lord,
lord.
yes, I'm coming. Page 97, my lord. Page 97, if your lordship will see, my lord, this so cause is at page 98, my lord, the operative portion.
Annexure A.
Yes.
Those
And
are
it's
the
a-
items.
Item. Yes, items are given, my lord. Items are, yes, these are the items. For which we paid for extension. only. 97, 97. Item 90, page 97, my lord. So come. And if your lordship see, my lord, the interesting thing is this is a so-called notice.
Yes.
Operative portion, if your lordship see, my lord, page 98,
Yes.
you are hereby asked to show cause why your product should not be debarred as per the referral panel clauses of the tender. So I have been asked to submit reply why my product should not be debarred. My lord, in the tender, my lord, there are two clauses. If your losses may just come to,
Sorry, from 98, what did you want to show?
my lord, page 98, last paragraph, you are hereby asked. Your lordship got it, my lord?
Yes, yes.
To show cause why your product should not be debarred as per the referral panel clauses of the tender. So this is what for show cause was issued. That why my product should not be debarred. Well, there are two types of penalties if your losses comes to page 44.
44.
44.
Yes.
Debarment, blacklisting for failure to execution of the supply so and so so and so. So product debarment, this is my lord, product debarment in case of non-supply or incomplete supply of the 90% so and so by the above manufacturer, importer, firm within the agreed delivery period, including the delay penalty period or any such extended delivery period, the concerned rate contract shall be cancelled and the manufacturer, importer shall be debarred from participating in any bid by the authority for 5 years from the date of debarment for that item. This is, my lord, the product debarment. This is the product debarment. Then second clause is, my lord,
Farm department.
farm debarment. This is blacklisting. So
But what did the show cause said?
show cause is for product department. Show cause is for product department.
Is it?
Yes. It is not for blacklisting, my lord. Supreme Court has made very clear
Why
that
your
show cause-
product should not be debarred? You are
Yes,
correct. Product debarred.
this is product. Now,
But then they blacklisted.
my lord, here, let's see, my lord, at page 101, we have given the show cause reply.
Yes.
Saying that, my lord, we have successfully completed 80% of required supply and the remaining goods are currently at Guwahati. However, due to closure of the 11 purchase order, we are unable to deliver the pending items at this time. My lord, these are already lying with us, my lord. We could not deliver because they closed the purchase order. My lord, regarding so and so, we confirm the 100% quantities were dispatched. Unfortunately, due to mishandling of the transporter, the remaining quantities were not delivered as intended.
If we are granted an extension, we will dispatch the goods.
Yes,
Yes.
my lord.
Then-
Now, they have passed the order. This show cause, my lord, they have just given a reference only, but they have not considered it. Page 105, my lord. If your lordship see, they have,
What is the final order?
this is the final order. This is the final order. Just, my lord, reference clause 5, your lordship see, your reply dated so and so against the show cause notice. But if your lordship see the entire order, they have not.
Anyway, all that this court will not go, but what is the ultimate action?
Ultimate action blacklisting, my lord. How they can do it?
Where do I
Yes,
get that?
my lord, at page 106, third paragraph.
Therefore, in the greater in public interest, so and so, your company so and so is hereby blacklisted and debarred from participating.
Blacklisting,
But,
my lord.
Now, before taking before blacklisting, notice has to be given.
Yes,
Where is that clause?
my lord, page 44, my lord, it is there.
In
And-
case the firm is blacklisted, debarred, banned after the
Yes.
submission of many inform, no. Where is the notice part?
Notice part, my lord, Supreme Court has clearly said, my lord, the so called notice clearly saying that what action will be taken.
No, here in this, in these conditions, anywhere said that before taking any of these, measures,
My lord,
for supply and non-supply default, a notice has to be given because, I have seen that, under this, there can be a product debarment, there can be a firm debarment. Firm debarment is when, both product and blacklist,
Yes.
correct?
yes,
Now, apparently, what you are trying to project before this court is that in your notice, the proposed action was only product debarment.
product department,
However, they didn't stop there, they were also blacklisted.
blacklisted, my lord.
This is what
And
you are
yes,
trying
my
to
lord.
say.
And now, my lord, Supreme Court has come to this, my lord.
Because right at this moment, this court will not go and see whether this product debarment is correct, not correct, because it appears that admittedly you have not, there has been some
My
short
lord,
supply.
that is correct, but
Now,
this is
these
what-
are, no, why I'm saying, because this is ultimately going to be decided, the matter is yet to be heard, department is yet to file their counter.
my lord.
But as far as blacklisting is concerned, yes, Mr. Gogoi,
My lord.
And moreover, my lord, last time I have submitted my honorable judge has referred to 3 judgments, my lord, that hearing should be given, my lord. There are judgments.
where are those judgments? I cannot be referring to orders, I have to see the
No,
judgment.
no, Honorable Court has just recorded the citations, my lord. The moment there is a direction.
I can give fresh, my lord.
I have to see them.
Yes, I can give fresh copies also, my lord.
Or may I, my lord, if your
Yes.
lordship allows,
Yes.
may I place the entire record of the proceeding, my lord? Because lordship will see, the purchase orders are not part of the repetition, my lord. There are several purchase orders, just for a moment, my lord, before lordship, my lord, so other facts.
Have
my
you
lord.
marked them or you can refer?
Page 95, lordship may kindly see, my lord, for.
Page 95.
95.
My lord,
Mr.
this is.
Naila, one second, I'll
Just-
come to
just-
you.
Yes,
One
yes,
second,
yes,
just hold
sure,
that.
sure.
Page 95, lordship will see, after the prayers, prayer for extension of delivery prayer. All these are purchase orders, my lord.
Sorry.
My lord, in the page 95,
These
after the
other
subject,
numbers.
reference, yes, these are all purchase orders.
So there are 1, 2, 3, 4, 5, 6, 7, 8.
When these
9,
orders were
10,
issued, my
11,
lord, those dates are not here, my lord.
12, 13,
And my lord, they have not been annexed. So lordship will see how much orders,
So total 19.
almost, my lord, 19, my lord, he failed to supply.
And
And
that
from-
extension that was sought is in respect of?
These
My lord,
items.
These items, 19, my lord, 19 purchase orders. My lord, these are
No, so therefore, that is why.
essential drugs, my lord.
you see,
Lordship will have to see when the orders were issued.
Boy, that is why this court is asking you from the records that you are holding. What happened after because it is your letter where you said you had allowed them to clarify
My lord.
within a day. Therefore, as directed, I am to inform you that against which you have, for which you have requested for extension should also include the item name and tentative date of supply from your end.
My lord.
Now, they have given this item name. What have you done from the records? What does the record says?
My records otherwise, my lord, so far as my entire
But
record
Mr.
is not
Saib,
available.
The 95 document doesn't show the date.
No,
No,
dates are there, my lord.
order numbers are there, my lord. They know it, my lord.
Mr.
For the code,
Saiwala,
it is-
94, if you see, 94 says for extension should also include the item name, sorry.
Yes.
Tentative date of supply.
At date of supply, we have given, my lord, for 15 days.
Yes, you have given.
15 days.
Yes,
my lord.
what have you done, Mr. Gogoi? I'm repeatedly asking you only one question,
Yes, my lord.
because this is your,
No, I understand, my
Like you
lord.
have-
Our mail, my lord, he responded. Now what is the
what have you
outcome?
done? What is the outcome of that?
That, my lord, perhaps, my lord, is not there because that
But
pair.
that is the only thing you need to show today, because otherwise, matter
Then, my
has-
lord, no, I will place the entire proceeding, my lord. Let it be on Wednesday or tomorrow, my lord.
tomorrow.
Tomorrow. Yes, my lord, I will place it.
Because
Flag mark and I will place
see,
it.
I am not on the entire proceeding right now,
Lordship.
because I am not taking up this matter for final disposal. We
Lordship.
cannot dispose of matters like this where we
Yes,
don't
yes.
give a chance to the other side to
Lordship.
rebut. You see, you'll have to file your affidavit. That is another thing.
My lord,
But because an order of blacklisting is already in existence,
Lordship.
so if we find that without considering the extension request, you have blacklisted, then perhaps a prima facie case of granting.
My lord, one thing, my lord.
Well, this is only for interim, because you see, I'm not hearing the matter.
Yes, of course.
Final relief is different.
But, my lord, it's,
You may have a case.
yes,
I'm
because,
not
my lord,
saying-
just because somebody submits a prayer for extension, it's not that we are bound to
Gogoi,
give it.
Your department has said, you give us this and this.
My
What
lord,
did they do?
what is the outcome or whether it was considered or
Don't
not?
come up with a piece of letter. It has to, your record has
No,
to.
no, original record will be placed, my lord.
Heard Mr. G.N. Sahewala, Learned Counsel, Senior Counsel, assisted by Miss
TJ Sahewala. TJ Sahewala.
TJ Sahewala, Learned Counsel for the petitioner. Also heard Mr. D. Gogoi, Learned Additional Advocate General
My lord.
for the state respondent. Mr. Gogoi submits that he has received the records.
No records, my lord, I got some documents.
He has received few instructions in the matter. Accordingly, the matter was, in terms of the earlier order passed by this court, accordingly, the matter was taken up for consideration of the interim relief. However, during the course of the hearing, it appears that the order of blacklisting does not appear from the record to have been. Don't say that. However, it appears that though the petitioner company
Yes.
was blacklisted by the impugned order dated
My lord, it is, no, the date people.
impugned order dated so and so,
My lord.
for non-supply of the
Date,
subject items.
That nahi ruking.
It appears that the petitioner has sought extension for supply of the said subject items, which the respondent had asked the petitioner to submit the details of the items by the next date with tentative date of supply, which the petitioner did.
Yes.
However, there is no document to show that the department has considered the aforesaid aforesaid request of extension. Accordingly, Mr. B. Gogoi, Mr. B. Gogoi, Leonard so-and-so will apprise the court tomorrow as regards the faith of the extension as sought for by the petitioner.
Well, it should be 60, although it is not mandatory here. 10-3.
Not
10-3, no? 10-3.
Order, impugn order is 10.
Impugn order is 10-3, 2025.
Yes, 2025.
Tomorrow.
Civil say, my lord, I will place the record. I will place the record.
You place whatever. I am only on a small.
Yes.
The query of this.
Whether
court
before
right
debarment,
now
my
is
lord, yes. that-
What has happened, because I mean, for passing interim order, this court is not going to hear the entire matter.
Lordship.
Otherwise, what is the use?
My lord, my lord.
This court, if it's a prima facie case is made out, the court is going to give him the interim. That is the principle at the end.
Lordship.
They have sought an extension. You yourself have sought. Next day, you give me the details. They have given the details.
No, details, my lord, yes.
They have given.
It has been mentioned, my lord. Let us see what is there in that.
They've given the details, and instead of considering that, you have blacklisted.
That the record will speak.
Prima facie, they have a case as on date. Yes.
But
Itu kailo ikane pothai dibo. 50.
May I please your lordship? This IA was filed by the writ petitioner lordship for a direction to the authorities to release the Jirat compensation lordship in favor of the lordship present applicant lordship. As admittedly lordship, they are in the possession of the land. lordship.
Steps were required to be taken.
And
It's completed. Get home.
that's completing it. My lord, may I say one thing, my lord, in
Last order, it says the learned counsel for the applicants shall take appropriate steps in that regard. Pursuant to the order so and so, it has been informed that NHIDCL is the appropriate authority for whom the land has been acquired.
Thereafter,
NHIDCL is made a party.
Lordship,
You are
we have,
NHIDCL.
I am for NHIDCL Lordship.
Yes.
already amended, my lord.
And what is this IA for?
My lord, IA is regarding lordship, release of the Jirat compensation, because there are two components of compensation lordship. One is the land
Yes,
compensation.
you want to file something?
Lordship, may kindly para 6 of the IA, Lordship.
Yes.
May I read your Lordship? That the applicant beg to state that although the compensation for structure Jirat as well as the land compensation was sanctioned in the name of the petitioner, but the concerned authority did not release the same to the petitioner on the plea that some other person filed a complaint against the compensation. Your Lordship. In this regard, Lordship, I have received an instruction, Lordship, from the competent authority for land acquisition, Your Lordship.
Lordship,
Have you got a copy?
no, lordship, I have not received the copy. Some
Lordship.
development take place, lordship. I have received the copy of the order, lordship, that 50% of the Jirat compensation was lordship paid to the present applicant.
As per 3G, Your Lordship, some other parties are in, other parties' names are there, Lordship. He has not been made party, I think, here.
No, their names are not there, lordship. Lordship, in the 3G notification, our names are there, lordship, being the sole possessor, as we have.
There is some dispute.
There is some dispute.
There are
Lordship,
some
with respect
dispute
to-
regarding land, lordship. But Jirat, lordship, because petition number 1 having a 5-storied building, lordship.
Why don't you file an affidavit?
Lordship, I can file an affidavit. Lordship.
How decide all this like this? File an affidavit.
As per 3G, Your
Lordship,
Lordship, some other person
that
names
means
are
I have
included.
vacate the land, lordship.
Mr.
R. Boro, Lordship.
It's R. Boro.
Boro, Lordship.
Learned Standing Council.
On behalf of C. Boro, Lordship.
Learned Council appearing on behalf of NHIDCL respondent submits that he has received instruction in the matter. However, seeks to place the same by way of an affidavit. Prayer is allowed. List out of date of next week.
No, some more time is required, Lordship.
After next week.
20 June. Lordship.
Obliged.
Obliged, Your Lordship.
Withdrawal of prosecution case.
Lordship, this IA was filed for trial of some appropriate proceedings in against the contemnants, Lordship. On the last judicial order may peruse, Your Lordship, notice was issued. But the office note transpires that neither the
Service in respect of.
neither the AD or answer notice has been received. But Lordship, one thing.
List after 3 weeks on a date to be fixed by the registry. Await service.
Await.
May I please, my lord?
Early date.
Yes, ma'am.
Early date. When?
After vacation.
In the month of July, my lord, last
July.
part.
What is the issue involved in the writ? The RSA.
Yes,
RSA
RSA regarding in money suit.
55, no?
55.
Heard Mr. A.K. Gupta, learned counsel for the applicant, also heard Mr. S. Islam,
Lordship.
learned counsel appearance for the
Sole
respondent.
respondent.
By way of this application, the applicant is seeking an early date of hearing of the regular second appeal, RSA number 50 of 2019. In the RSA, the TCR have.
LCR receipt.
It appears that in the RFA, the case records have been received and the matter is ready for hearing. Mr. So-and-so learned counsel for the respondent does not oppose the listing of the matter on an early date for hearing. In view of the urgency expressed by learned counsels appearing for both the parties, the application, the prayer for early listing of hearing is allowed. Accordingly, application stands, accordingly, it is provided that the RSA be listed for hearing in the month of August 2025 on any date to be fixed by the registry. Application stands disposed of. Because July, that it's already summer break.
Yes.
On the reopening, it'll be very busy. You have it in August. Yes.
My lord, in this case, my lord, respondent number 4 died, my lord. So actually, he died during the pendency of the first appeal, but we do not know about that, my lord. So only when the second appeal was filed, notices were issued, my lord. My other side has informed about the date, my lord. Then, my lord, after he has provided the information, these applications are filed. I have filed 3 applications, my lord. One
Condonation, setting aside abatement and substitution.
So, lordship may kindly take up first, my lord. I
Yes,
just
Mr. Kaushik, any
But
objection?
perhaps notice has to be issued to the
legal yes, ma'am.
persons who are
First
to be
and
substituted. It has
First
come.
time it come, my lord.
In the meantime, my lord, I'll also file my objections, my lord.
That notice will perhaps go in the condonation.
In the condonation.
The IA 1
Condonation is 1453.
Yes.
1453.
Issue notice, you are accepting for
I am accepting for my lord 2, 3, and 5, my lord.
2, 3, and 5. B. Kaushik.
My lord.
And in respect of
4 is the deceased respondent, my lord, whose legally they are seeking substitution.
steps in respect of the proposed legal heirs of the deceased respondent number 4 as per by registered post AD. 1A and 1B.
1A and 1B.
By registered post AD. You need an extra copy?
I have it.
You don't need, isn't it? Steps by registered post AD within a period of 3 days from.
Perhaps they will need to file an application for striking of the respondent number 1 as well, my lord.
Why?
Respondent number 1 also died, but the legal heirs are already on record, my lord.
That you see, Mr. Gupta.
That was also informed, my
I
lord.
will see. Lord.
You see?
I will look into that.
17,
List after 2 weeks? On a 2 weeks
Let
or
it be
3
after
weeks?
4 weeks, my lord.
2 weeks on a date to be fixed by the registry.
Obliged.
Grateful, my lord.
Yes,
Lordship, the IAs have come for the first time.
notice.
Yes, Your Lordship.
This is
Look.
for condonation
Condonation, abatement and substitution, Lordship.
in IA 15.
Lordship.
They have not-
1580.
They have not
They
they have
also
not
noticed
served
the-
copy, Lordship.
You are for whom?
Respondent,
Which respondent?
sole respondent, Lordship.
No, there are a lot of respondents. 1, 2, 3, 4, 5.
Lordship, in RS the Lordship, I'm,
Hmm?
in RS the Lordship, I'm sole respondent.
No, who has expired?
The appellant number 2, Lordship.
So you want to substitute the legal heirs of
Yes.
appellant number 2.
Yes, Your Lordship.
While doing that, there has been a delay.
Yes, Your Lordship.
And the statutory period has been also over for which.
Yes, Your Lordship. There's a delay of 608 days.
So you have also filed a legal setting aside of abatement.
Yes, Your Lordship.
Now, in this condonation, you have not made the original respondents a party.
I have made, Lordship.
Burroughs Memorial Christian Hospital.
Yes, Your Lordship. They are a party. Page number 3.
So who died? Number 1.
Appellant number 2,
Name?
Makhan Kans.
But he is, I think notice has to go to him also.
Yes, Your Lordship.
Issue notice.
For the appellants, we'll accept notice, Lordship.
Issue notice. And MS, your name?
P. Udhikari.
P. Adhikari accepts notice on behalf of the sole respondent. Extra copies to be furnished within a period of
1 week, Lordship.
what? 1 week?
2 days, Lordship.
2 days. To so and so. I think there is some wrong in the arrangement because you have to put till you substitute.
Lordship.
The legal heir cannot be shown as an appellant. I think they have to come under the.
In the amendment, Lordship.
Yes. And then as far as the condemnation is concerned, you'll have to put them in the, perhaps in the respondent column because notice has to go. They may have an objection.
Lordship.
You please look into it.
Yes, Your Lordship.
I can have this matter refixed.
Yes,
When, Wednesday?
Yes, Your Lordship.
You just say relist Wednesday. Have a look at it. I have a doubt as regards the, if anything is to be done, then you file an appropriate
Lordship.
application.
Obligation.
Attempt 8, you say, none appears on call, we list after a week or a day to be fixed by the registry.
For hearing. Number 58.
Yes.
Alert. Last time, Melon, we presented before Lordship.
I have forgotten everything, Mr. Patra Gohai. You'll have to refresh my memory.
Sure, Melon. Melon, both the petitioner before Lordship were removed from service on against the police, Simalguri police case number 37 of 1994 under Tada Act, then departmental proceeding was drawn, and simultaneously the criminal case that was also conducted, and by the judgment dated 21/7/2012, Annexure A at page 17 of the petition, the judgment by the Honorable Tada Court is there, wherein the court observed that the prosecution has miserably failed to establish that the charges against both of them, and there was another person, Dipen Jora. He was also accused of accused in that manner. And thereafter, when the judgment of the criminal case came, he was restored to service, and he has been continuing in service. But then both the petitioners are not getting any relief, and therefore we are before your lordship on the jurisdiction of the matter.
What happened to the main order? Order already passed, dismissed from service.
Yes, Miller.
But another person after the order also has been reinstated.
He is reinstated.
After the Tada Court's
after
order.
the trial court, after the criminal court judgment came up, exonerating all the accused,
including you both.
Including both of us, And I was referring to some of the opinion or some of the judgments of the Honorable Supreme Court, which is before your lordship.
Decisions are here.
Yes, Miller.
Last time you had given.
Yes, Miller. Then
Decision is this one. You have to file it now.
yes, sir. Yes, sir.
Oh, I get it. This I think Mr. Chutia had given. Ajay Kumar, you gave, no?
Oh, yes, Ojoy Singh.
Huh?
Ojoy Singh, I submitted.
Yes. And Ramlal, you had given.
We have met,
Yes.
Malad, our cases, before your lordship, we have given a list of 13 cases, We are not going to argue on all these, some important judgments,
So which is the decision that you want to rely?
Malad 2006, 5 SCC 446. Then 2024, 1 SCC 175. Then Miller, 2025
Where are
SCC.
the copies of these?
Copies,
Copies this, eh? Huh? Your junior has not yet submitted. They are saying they will submit. Let them give it in advance, not like this.
Yes, I'm sorry, Miller. I'm sorry.
Another date, you give all the decisions.
Milo. I'm sorry, Miller.
Yes, this is 2006,
Yes,
GM10. Yes, what do you want to rely from here?
Relevant para, Miller, para 30 and 31.
30 and 31.
Yes, Miller.
It was it to graduate. It was Ramlal I have.
Yes, Ramlal is also there, Miller.
No, but Ramlal last time you had given, so I have a
Yes, Miller. There's a
I've
foundation.
returned the duplicate copy.
Miller, my case foundation is based on 2006, Miller. That's why I'm just placing.
Yes, yes.
Para 30, Miller. At page 460.
Yes.
May I read, Miller?
Yes, please.
The judgment relied on by the learned counsel appearing for the respondents are distinguishable on facts and on law. In this case, the departmental proceedings and the criminal case are based on identical and similar set of facts and the charge in the departmental case against the appellant and the charge before the criminal court are one and the same. It is true that the nature of charge in the departmental proceedings and in the criminal case is great. The nature of the case launched against the appellant on the basis of the evidence and the material collected against him during inquiry and investigation, and as reflected in the charge sheet, factors mentioned are one and the same. In other words, the charges, evidence, witnesses, and circumstances are one and the same. In the proposed case, the criminal and the departmental proceedings have already noticed or granted on the same set of facts, namely raid conducted. This part is not much relevant, Milon, but then upper part is relevant. And then again, Milon, was the end, Milon. The same witnesses were examined in the criminal case, and the criminal court on the examination came to the conclusion that the prosecution has not proved the guilt alleged against the appellant beyond any reasonable doubt and acquitted the appellant by the judicial pronouncement with the finding that the charge has not been proved. It is also to be noticed that the judicial pronouncement was made after a regular trial and on hot contest. Under these circumstances, it would be unjust and unfair and rather oppressive to allow the finding recorded in the departmental proceedings to stand. 31 million. In our opinion, such facts and evidence in the departmental as well as criminal proceedings were the same without there being any iota of differences. The appellant should succeed. The distinction which is usually provided between the departmental proceeding and criminal proceedings on the basis of the approach and burden of proof would not be applicable in the instant case. Though the findings recorded in the domestic inquiry was found to be valid by the courts below, when there was an honorable acquittal by the acquittal of the employee during the pendency of the proceeding challenging the dismissal, the same requires to be taken note of, and the decision of Paul Anthony's case will apply. We therefore hold that the appeal filed by the appellant deserves to be allowed. Milord, secondly, 2024 1 SCC 175, Milord.
Yes.
It was 2020.
Maharana Pratap Singh.
Mano. Oh, man, this is 2025 Milord, SCC online,
Yes.
SC 890.
Yes.
My lord, the relevant paragraphs are paragraph 25. My lord,
Yes.
paragraph 25.
Yes.
May I read, Milord?
Yes.
The issues for the issues for determination that emerge for the decision are whether due process was followed in dismissing the appellant from the service and whether his dismissal from service is justified on facts and in the circumstances that have unfold before us, whether in light of the facts, evidence, witnesses, and the circumstances of the case, the charges in the criminal proceedings are substantially identical to those in the departmental proceeding, such that an acquittal in the criminal case would render the findings in the charge in the disciplinary proceeding vulnerable. whether the impugned judgment which allowed the appeal of the respondents and dismissed the writ petition of the appellant deserves to be upheld. 10. Whether the appellant is entitled to any relief should the aforesaid question be answered in his favor. My lord, thereafter, your lordship may kindly come to next paragraph, you know. 47. Yeah, para 47, Miller. I'm reading them.
47, yes.
Para 47, Miller. While an acquittal in a criminal case does not automatically entitle the accused to have an order of setting aside of his dismissal from the public services following disciplinary proceeding, it is well established that when the charges, evidence, witnesses, and circumstances in both the departmental inquiry and the criminal proceedings are identical or substantially similar, the situation assumes a different context. In such cases, upholding the findings in the disciplinary proceeding would be unjust, unfair, and oppressive. This is a position settled by the decision of GM Tang Supra, since the reinforced by the decision of this recently Ramlal versus State of Rajasthan, as I referred to in. My lord, next item, paragraph 50, Miller.
Yes.
The judgment acquitting the appellant reserves on the basis of the prosecution miserably failed to prove the case beyond reasonable doubt, as both the informant and the PW2 refused to identify the appellant in the court. This discussion confirms that the appellant's acquittal was based not on mere technicalities. In Ramlal Supra, this court held that the terms like benefit of doubt or honorably acquitted should not be treated as formalities. The court's duty is to focus on the substance of the judgment rather than the terminology used. Next, Miller, paragraph 52.
Yes.
Besides, the appellant's case is strengthened by the principle of adverse inference. It can be reasonably inferred that the respondents deliberately withheld the scanned copy of the departmental file, which was essential for us to assess whether the charges, witnesses, and evidence and circumstances in both the criminal and departmental proceedings were substantially similar or identical, likely due to concerns over the potential adverse consequences. Next parameter. In light of the preceding discussions and the adverse presumptions that is available to be drawn, we hold that the findings of the appellant being guilty of charge number 1 cannot be sustained following his acquittal in the criminal proceedings, which seem to have involved substantially similar or identical charges, evidence, witnesses, and the circumstances. Paragraph 55, Bina. Law in tried that while exercising its power under Article 226 and 227 of the Constitution, the High Court doesn't exercise powers that are available to an appellate court. It is the decision-making process that falls for scrutiny, be that as it may. The High Court can rectify errors of law or procedural irregularities, if any, that lead to a meaningful miscarriage of justice or breach of the principles of natural justice. Law is also well established that the standards for establishing a guilt in disciplinary proceedings differ from those applicable to criminal proceedings. However, it is equally true that departmental authorities are obligated to provide a fair opportunity to the parties involved, and what constitutes a fair opportunity must be determined based on the facts and circumstances of each case, as has been decided and laid down in the state of Mysore versus Sivaprangsa, this case, Milan. So basic thing is, Milan, that departmental inquiries proceedings, they will depend entirely on when the same charges, criminal proceedings were also going on. In the instant case before your lordship, that was there, both the proceedings were going on, and after the honorable trial court, that is the Tada court, came to a finding based on all the evidences which were there, cross-examinations which were made, wherein, Milord, the court has come to the conclusion that the prosecution has miserably failed to establish the charge that was leveled against all the accused, and as a result of which, Milord, by order dated 27/10, 2000, that order 21/7/2012, Milord, the judgment of the Honorable Tada Court is there, Milord. There are also some observations finally made on the basis of all the records, all the evidences, all the documents that were examined, Milord, and it was found that they have totally failed to establish it. So once it is established that all the proceedings has been exhausted procedurally, and the prosecution has totally failed to establish it, then in that case, they have got the honorable acquittal. Once they are honorably acquitted, then in that case, Milord, the departmental proceedings cannot go beyond that. Departmental proceeding will left therein, Milord. That is our argument, Milord. In all these cases, and there are other cases also there. Milord, these are the three important cases we are presenting before your lordship, so that. And another important thing is, Milord, that on the point whether a court can intervene or interfere with the decision of dismissal of service, there are two judgments, Milord. 2013 1 SCC. Page 598. Relevant. 24.
Yes.
2013 1 SCC 598. My lord, the relevant paras 24, 25, and 27, you know.
20?
24, 25, and 27.
Yes. Yes.
My lord, may I read it? It's page number 609. The honorable acquitted. The meaning of the expression honorable acquittal came up for consideration before this court in RBI versus Bhupal Singh Panchal. In that case, the court has considered the impact of Regulation 46/4 dealing with the honorable acquittal by the criminal court on the disciplinary proceedings. In that context, this court held that the mere acquittal does not entitle an employee to reinstatement in service. The acquittal, it was held that to be honorable. The expression honorable acquittal or acquitted of blame, fully exonerated, are unknown to the Code of Criminal Procedure or the Penal Code, which are coined by the judicial pronouncement. It is difficult to define precisely what is meant by the expression honorably acquitted. When the accused is acquitted after consideration of all consideration of prosecution evidence, and that the prosecution had measurably failed to prove the charges leveled against the accused, it can possibly be said that the accused was honorably acquitted.
Yes.
My lord, next para. In R.P. Kapoor versus Union of India, it was held that even in the case of acquittal, departmental proceedings may follow where the acquittal is other than honorable. In the state of Assam versus Raghava Rajagopalachari, this court quoted the approval of the views expressed by Lord Williams in Robert Stuart Ochape versus Emperor, which is quoted below, paragraph 8 below. The expression honorably acquitted is one which is unknown to the courts of justice. Apparently, it is a form of order used in courts, martials, and other extrajudicial tribunals. We said in our judgment that we accepted the explanation given by the appellant, believed it to be true, and considered that it ought to have been accepted by the government authorities and by the magistrate. Further, we decided that the appellant had not misappropriated the monies referred to in charge. It is thus clear that the effect of our judgment was that the appellant was acquitted and fully and completely as it was possible for him to be acquitted. Presumably, this is equivalent to what the government authorities say honorably acquitted. Below paragraph 27. We have also come across cases where the service rules provide that on registration of a criminal case, the employee can be kept under suspension, and on acquittal by the criminal court, he be reinstated. In such cases, the reinstatement is automatic. There may be cases where service rules provide that in spite of domestic inquiry, if the criminal court acquits an employee honorably, he could be reinstated. In other words, the issue whether an employee has to be reinstated in service or not depends upon the question whether this service rule contains any such provision for reinstatement and not as a matter of right. Such provisions are absent in Tamil Nadu service rule, as the case may be. My lord, another matter, my lord, it is 2013 3 SCC. Next case, my lord, we are presenting 2013 3 SCC, page 7.3.
Paragraph 9,
9,
10, 10, and 12.
My lord, paragraph 9, 10, 11, 12, my lord. Relevant paragraph. It is in page 76.
Yes.
Para 9. The doctrine of equality applies to all who are equally placed, even among persons who are found guilty. The persons who have been found guilty can also claim equality of treatment if they can establish discrimination while imposing punishment when all of them are involved in the same incident. Parity among co-delinquents has also to be maintained when punishment is being imposed. Punishment should not be disproportionate while comparing the involvement of the co-delinquents who are also parties to the same transaction or incident. The disciplinary authority cannot impose punishment which is disproportionate or lesser punishment for serious offenses and stringent punishment for lesser offenses. Below paragraph 10. The principle stated above is seen applied in a few judgments of this court. The earliest one is DG of Police versus Dasayan, wherein one, the Sion, a police constable, along with two other constables and one head constable were charged for the same acts of misconduct. The disciplinary authority exonerated two other constables but imposed the punishment and dismissal from service on the Sion and that of compulsory retirement on the head constable. This court, in order to meet the ends of justice, substituted the order of compulsory retirement in place of order of dismissal from the service on the Sion, applying the principles of parity in punishment among co-delinquents. This court held that it may otherwise violate Article 14 of the Constitution. My lord, because it is in context to three of us who are all are accused.
One has been reinstated pursuant to the trial court.
Pursuant to the trial
acquittal.
court judgment, and we were removed from service. My lord. That is the point of discrimination that has been made to. So, Honorable Supreme Court has said that that cannot be done. Then paragraph 11, Miller.
Here, the allegation was that you are a terrorist or something.
Yes, Miller.
That was the allegation.
Section 3 and 4 of the Tadai, that we are involved with terrorist activities.
But there was nothing, no materials.
No material could be established, Miller.
And
And
the charge sheet also is that you are associated with.
Right. But then, yes, Miller. But then they could not establish the charge as they were in the inquiry. Another thing is, Milan, the confessional statement that is alleged by the prosecution, it is not corroborated by any other substantial evidence of which is reflected in the judgment of the Honorable Tada Court, Milan. That
There
means
is a confessional statement of you before the disciplinary authority.
no, yes, before the disciplinary authority.
Saying what?
That we are involved with the activities of terrorist technique. But then that was not corroborated. Even the cross-examination, Milan, that is established. If your lordship comes to the judgment of the Honorable.
No, before going that, where is that confessional statement? Is it there in the records, Mr. Jyoti?
Yes, yes, Bhalat.
Can you read it out for me?
Yes, Bhalat. Yes, I can read. Confessional statement of the Arun Kumar. My name is Arun Kumar. I was born in the month of July 2020 in the village of so-and-so under Sibsagar. I had my primary education so-and-so high school so-and-so admitted in the first year so-and-so. I could not complete further. The Ulfa active Babulpur, and Midul Pavan Gogoi of Bengumaria Korgao asked me to attend Ulfa meeting in the house of the man of Handigao. I accordingly proceed to that house accompanied by Babul Kaur and Midul Pavan Gogoi. They are the following person participated in the Ulfa meeting. The person was there, but eight person are there. They are attending the meeting, and he was also brought to the meeting. That is the statement. I had moral support of Ulfa organization. Babul Kaur and three women, name not known to the, delivered excited speech and exhorted us the aim and object of Ulfa organization and asked us to carry out the order of the senior members of Ulfa organization who were given political class in the meeting. Babul Kaur prepared the list where I put my signature and my name was given as Sagar Borwa. Instead of Arun Kaur, his name was in the Ulfa organization, Sagar Borwa in the Ulfa organization. Bhupen Phukon of Rohdoi Pukhuri, Patorgao and the Durga Gogoi of the Bengumaria Korgao asked me to work for contact number 1 party, the Panchayat election
or asked me to Congress party in the Panchayat election. Durga Gogoi, one of the candidate for the Panchayat election. Accordingly, I work for them. Bhupen Phukon prepared the list consisting of 10 men, members of the government service in his 1992. I prepared for the post of I participated in the post of UB constable and handed over from duly filled up from post of constable. That means, but he say he got the job before joining Ulfa organization. Malot. He was earlier Ulfa organization. He was Congress party manu. He was assisted by them, and that's why they have got a job. And now they are saying I was taking a Sibsagar PS so and so, Bhupen Bosu. But only I have seen, my lord, I have to say the truth, my lord. That has been recorded by KM Sorma, APS Superintendent of Police in English. And petitioner here, he has put his signature, Gute Sikarati Pohisalu, Ebila Kintu Mur Nohoi, Orun Kun. So that's why, my lord, I doubt it, my lord. Though I am submitting our ballot prosecution, my lord.
True, you are being fair.
Yes, that's why, my lord, I have seen here, my lord. So other is nothing, my lord, only that is there. And one letter is there, my lord. This letter says, as per your Nidekhana, Apnaloko Nidekhana, but a more confessional statement of Pothai whole. Be that as it may, my lord, on the basis of the concentrated confessional statement, if the department of proceeding is, my lord, concluded, that is to say, my lord, I should submit fairly, my lord. It may not be his statement. So, as this states, my lord, delay and lessons is heated. Petitioner is 92 and 96 he was removed, and they have come before lordship now. So, if lordship allowed the petitioner to reinstate it immediately, my lord, they will get hardly 3, 4, 5 years job and without backward. Then I have nothing to say. On the records, my lord, I have gone through it, direct me to see the records. I have gone through the records each and every time, but there is no lapse in the procedural part. So goes what issued, reply given, an inquiry report submitted, inquiry report along with a
But
second.
one thing is there, the charges is identical. The
Yes,
basis,
that I read
the
it.
basis of your departmental proceeding is that he's a terrorist, correct? This, the criminal court have said that the prosecution has miserably failed to establish.
Failed to examine. But only question is they were acquitted beyond reasonable doubt. No, only benefit of doubt. The Supreme Court says benefit of doubt is if it is acquitted with benefit of doubt, that it is not said honorably acquitment. That point is there.
Even prosecution has miserably failed. Now, many times when we write judgments, we use beyond reasonable doubt.
That is
But at the end of the day, you have to see the judgment.
I have seen the judgment cited by
No, not those judgment. The judgment of the trial, correct?
Yes.
Now it appears from the trial court judgment that there was nothing. Now that is why I asked about the confession, because had this confession be there, you see, sometime in criminal court, the confessional statement may not be evidence.
May not be, but in Department of Prosecution it can be.
Correct.
Yes.
Therefore, I asked what is there in the confessional statement.
Yes. So
that could have been a different situation, Mr. Chutia. But then you being an officer of the court has made a very fair submission.
Yes.
So
that's why, my lord, I go through the record.
Perhaps the confession statement will also be of no relevance in the department.
Well,
now, if that be so, then and the fact that one person has already been reinstated, now not to give them I think overall.
Only a airport authority of India, I have seen one case. Confession made by the employee could be admitted in evidence in Department of Proceedings.
Correct. You see, Mr. Chutia, there is no. You see,
that's why I don't want to place all this thing.
I heard the confession statement. Because I was with the petitioner.
Yes.
Till then, but the moment he said there is a confession statement, immediately I asked you because of this.
That's why, my lord,
if the confession statement appears to inspire confidence, then this court would have not interfered with the with the penalty.
That's why I'm reading all these things, my lord. I don't want to hide anything.
Then
so my submission for lordship, if allowed, then they will get about 3-4
Where
years.
the other reinstatement was done immediately.
Yes, my lord, immediately after the pronouncement of the judgment.
Guara.
When was the pronouncement done?
It was on 27/10/2012, my lord.
27?
21/7/2012, my lord.
21/7.
2012, my lord.
Why have you come after so long?
No, my lord, our case was pending from.
Oh, 12.
Yes, sir.
12.
Well, there is, of course, there is
Only
no
after the
bar.
judgment of the.
There is no bar to come to this court.
2012.
Yes.
They will obviously come after the judgment only.
The
Because
judgment-
their whole case is that now that the very basis of the disciplinary proceeding charges was the about him being a terrorist that the criminal court have acquitted, and based on that one person has already been given the benefit.
Yes,
That
yes.
is their whole case. How
Yes.
can they come before 2012?
Yes.
Where is that order of reinstatement of the other person?
The lordship will get it at page 5 of our writ petition, my lord. In the affidavit in reply, by
Yes.
respondent number 4, my lord. In paragraph 4,
Wait, I'm yet to find that affidavit. Which
my lord,
affidavit?
affidavit filed by respondent number 4, my lord. It was filed on 21st January 2013.
Oh. Paisu.
Yes. Dilip Borua.
Yes.
Yes, Dilip Barua. Page?
It is page, internal page 2, my lord.
Paragraph 4.
Paragraph 4, my lord.
Yes.
Made it, my lord.
Yes.
That with regard to the statements made in paragraph 8 of the writ petition, the deponent begs to state that UBC 255 Dipen Dwara of Jorhat, DEF, when posted at Jorhat PS on 19/3/94, was arrested in connection with the Simolgui police case number 37 of 1994 under section 3 and 4 of Tada Act as intimated by the Superintendent of Police Sibsagar via his number DSB SBR 944951 dated 19/3/1994 and memo number DPS SBR 954441 dated 30th March 1995, and the state constable was later released on bail by the designated court on 7/11/1994. Subsequent to his arrest, UB 255 Dipen Dwara was placed under suspension by the Superintendent of Police Jorhat with effect from the same date, that is 19/3/1994, by DO number 842 dated 22nd March 1994. In 2003 departmental proceedings, DP number 10 of 2002 was initiated against UBC 255 Dipen Dwara by the then Superintendent of Police Jorhat by DO number 1995 dated 16/7/2002. The last so-called notice was issued to him by number RO DP 2003-256 dated 10/1/2003, to which the said constable submitted his reply on 21/1/2003, which was not found satisfactory. The office of the deponent ordered that the DP to be continued, and Sri K.K. Chaudhary, APS, did an additional SP Jorhat, was appointed as the inquiry officer. The DP was subsequently inquired into by Sri Gautam Bora, APS, did an additional SP Jorhat. Sri P.K. Das did an CI Titapur, and Sri Devendra Daka, APS, did an additional SPS Jorhat. Meanwhile, the order of suspension of the said constable was revoked
But that
by
was
the.
different.
Before Department of Proceedings is closed, it suspected for
This was different.
different, my lord. It is a, own
No, my lord.
for cases, but on the basis of that.
No, no, in the second page it is there, Miller. So meanwhile, the order of suspension of the said constable was
Revoked by the.
revoked by the office of the deponent by order dated 36/2007. Findings of the DP numbers 10/2002 submitted by the inquiry officer D. Deka APS additional SP Suyanshu Jorhat. The findings indicated that the charge could not be proved as per the requirement of administration law. However, as recommended further development action taken up as per the verdict of the Honorable Court, the DP was dropped on
Honorable
13
Court verdict, which verdict?
this
Against Dipendwara.
Dipendwara.
That was different.
No, this is there.
No, that means they were, basically he was a similarly situated.
Similarly,
I was thinking that together with you two, he was also there because his trial court judgment came earlier. The trial court acquitted you when? In 2012, you said.
2012.
And here in this case, he was acquitted sometime in 2008.
2007, but then, my lord, the evidences and all the records, the documents they have produced. So all the sets of documents, all that witnesses.
That's all right. I was thinking something else.
Yes, yes.
I thought that three of you were together put to trial.
No.
Yes.
That is not. You were not put to trial together. And were you charged together?
No, separate.
No, my lord, if your lordship comes to page 17 of our writ petition, my lord,
Yes.
your lordship will find the parties, the Honorable the Designated Court Assam, present AC Suyanshu, the State of Assam component versus Arun Kumar, Achyut Hatimoria, Dipen Duara, Sri Nilut Raj Kumar.
Who are the petitioners? Arun Kaur.
Arun Kaur is petition.
And?
Arun Kaur and Achyut Hatimoria.
And this person?
This person is also implicated therein, my lord.
Dipen Borua.
Dipen Duara.
Dwara.
Dipen Duara.
This is of this case number 2000.
That is Sada case number 118 of 2000.
No, but this judgment came in 2012.
Yes, yes.
But it was against him, charges were dropped earlier.
No, what I want to place before your lordship, that when both of the petitioners.
Mr. Bharpatra Guhai,
Yes.
have you understood the query of the court?
Yes, yes.
Or maybe I have not understood something.
No,
It
no.
could be one thing. Because as far as Dipen Dwara is concerned,
Yes.
in that affidavit, it appears that the disciplinary proceedings
Yes.
in respect to him was dropped way back in 2008.
Yes, my lord.
Correct?
Yes, yes.
However, in your case,
The judgment came in 2012.
judgment came in 2012.
But my
So you cannot say that in Dipen Dwara case, because of this judgment, he was given, charges were dropped. So you cannot draw that similarity.
my lord.
You understand what I am saying?
Understand.
For whatever reasons, against him it was dropped earlier.
That is true, my lord.
Not because of the trial court judgment.
Yes, my lord.
However, in your case, you are saying that now that you have been convicted while it was dropped against him.
Right.
Your conviction came when?
94.
Huh?
93 or 94.
94.
94. 1994.
Yes, yes.
94.
The disciplinary proceeding.
Yes, my
Yes.
lord.
And ultimately he was removed in 2006.
Removed in 2006.
He filed appeal.
Petitioner number 1 was removed from service on 27/10.
However, in 2007, and at that time, this Dipen Dwara was also removed.
2004. He was also under suspension.
I think I'm a bit confused with all the dates. Why don't you prepare a list of dates
My lord.
And for the assistance of the court, we
My-
can have this matter Thursday.
My lord.
You give me a list of dates,
My lord, we'll do it.
the entire sequence.
We'll do it.
Argument is this only.
We'll do it.
And you had already benefit of doubt is what is your argument, right, Mr. Chutia?
Yes, yes,
You had given Ajay Kumar Singh for that.
yes,
So argument otherwise more or less is concluded.
concluded.
But I have a little doubt as regards the sequence of the dates. So if you can prepare
My lord, definitely will.
that you give me on Thursday, if possible in the court, I can dictate the order.
Must have.
Blinders.
And another case is the Airport Authority of India confessional statement can be taken into consideration.
That anyway will not come in because
Because due to this, yes, I have.
so this court unnecessary.
Thursday.
Why should I labor into that?
Yes, yes.
But that's a well settled. You see, Mrs. Chutia, the moment I asked you was that. Because if your confession statement was proper, I could have stopped it there and dismissed this.
Yes,
petition.
yes, my lord. I have seen, that's why, my lord, lordship can see it, my lord, page
Yes.
9.
But after that, then it is not fair.
That's why my lord, I have also some doubt.
But you try and see before Thursday because
My duty is to
you are right. Here he has been removed in 94.
94.
Now 2012, after the trial court acquitted, he has filed. Unfortunate, this case also
2005.
yes. So ultimately, what relief can this court give?
Yes.
If you can have some
That,
authority,
yes, I have a case, my lord, case law. Z tank case, my lord, I can give it, my lord.
I think G Tank you have also given no.
Yes, yes, yes.
My lord, GM tank cases, my lord,
Yes.
is here ultimately.
Huh.
Dismissal order passed on 1982. He was dismissed from 1982 and he put 20 years of service from 1953 to 1979 till suspended. He was suspended in 1979. Appellant retired from service in 1986. The criminal court acquitted him in 2002. Until such acquittal, there was no reason to hold the dismissal erroneous. And any relief monetarily can be only from 30th January
Give
2002.
me that.
I will give you, Lordship. Therefore, we deem it proper to set aside the order of dismissal without break wages.
All right.
I am pressing not to pay any break wages. If it is,
All right. Give it.
I am giving this case.
Just highlight that portion.
Yes, yes, I had it.
You have given all your case laws, no?
Yes,
As per that
it
list.
is 2006. 5 SCC 446.
If there is anything else from that list which you have given, then you just give it to the court martial, the photocopy, because I'm going to read it. That's why I'm saying. Because I would want to dictate it on Thursday.
Sure,
All right?
sure.
Only
we'll
just
provide.
give me the dates.
We'll provide.
Heard in
We'll provide.
part, relist Thursday.
Must have.
This is the gist of the case and highlighted it. Paragraph.
To file out did you?
In such a situation, how relief can be given?
And that confession statement, just keep a photocopy with
Photocopy, I will provide it.
Just keep it with you.
Yes, yes, yes. Photocopy, they
My
will be
lord,
double
one,
copy.
one point I'd like to raise for you. The confessional statement by my learned friend is showing it is before the police officer.
You see, I'm not going into that.
No, no, but just
I understand you're saying that any confession made before the police officer is not evidence.
and another thing is, my lord, in the judgment of the.
But that perhaps could be for the disciplinary, sorry, for the criminal trial.
Right.
Now, this is a disciplinary proceeding.
My lord, when it is established.
But
that it is-
you see why unnecessary these arguments are coming because Mr. Chutia, in his usual fairness, himself before even handing over the records to the court have said it that the confessional statement doesn't appears to be actually a confession statement made by the petitioner.
My lord.
This is what has done.
Exactly, Bala. That's why I am pointing.
He's being so fair.
I should not point out events.
But no, you should, Mr. Chutia, because you are an officer of the court.
Yes, I am
Yes.
assisting the court. That's why, Bala.
So he, in his usual fairness, he's always been very fair to the court.
I just said.
After that submission, anything else to
No,
say?
nothing.
Then
Nothing.
Only list of that he will provide it, my lord. Lordship can pass.
We'll provide.
I will provide photocopy of the copy.
yes, please.
Otherwise, my lord, I can give the original also, my lord,
All right,
or all of the ATM, my lord.
okay, okay. You just,
I have
if
pointed
you're
out all
happy
these
to
things.
give it to him then.
No, I have made all this, my lord, all these things, no problem.
Because I don't think we need to go into the record.
No need, my lord. I have provided here a list, what is the page of compensation statement, lordship can only see it.
All right, you leave it.
Yes, that's why, my lord. There's a, my lord, gist is there.
This is the records of,
Record of our own court.
which is, Masha, sit down. Sit down. Mr. Shri Nutya has placed the records of the disciplinary proceedings pertaining to the petitioner's case, which is kept for perusal. Just put that. It will.
Much obliged, my lord.